Allora,
Yes.
We have been granted 2 years ago. In a sudden situation which yesterday, we require relaxation.
We will come to under the topic.
Tomorrow, can it come today in the supplementary test because then the report can be called for from the state that we got out small. Otherwise, I will have no redress to.
Who generally represents Mr. Kumar is not appearing in the criminal.
Inform the public prosecutor, Mr. Panuka.
Inform it that we are permitted to appear tomorrow.
Tomorrow, then the report.
Today till 12 we are taking up this decision.
It may come in the supplementary test. Supplementary.
Then we will come and say we will take up whenever it come say around 11:45 just mention. Yes.
Your Lordship, I am mentioning a very urgent habeas corpus petition matter
Yes.
of illegal detention. Even after satisfying the date rate surety bonds to the authorities, Your Lordship, the jail supervisor, the superintendent has claimed that he will be holding for another 2 months. He can make the decision. My Lord, I am training leave to file this habeas corpus petition. And
This will also appear tomorrow at the top.
my
Tomorrow at the
today
top.
it can be
No, from today.
leave very granted.
Leave is granted, it will appear at the top tomorrow.
Pecuniary goods.
Please.
What?
No, we mentioned top heading. Top TOP bracket habeas corpus থাকবে। Good. আর এক দেশে appears to be mentioned. One is
Yes,
person.
So. No one for judgment, that was 64, that was the highest, that was the.
According Mr. Venego. Accordingly, WPCT 54 of 2025 and WPCT 7 of 2026 is dismissed on contest. They are affirming the input judgment there. We have said also PCT 6 of 2026 dismissed. That judgment is there.
All right. Blair.
Before publishing them is taskers. W should be properly written.
That electricity might have just 7.5. It is been
1140 we will fix another matter.
but as actually the order sheet that
Oh,
for
1140.
filing that not regarding the
It's not yet ready.
information is going. Immediately when they comes, I will.
When it comes, inform Mr. Tabriz and Mr. Prasad. Just mention it. We will take up the matter which is going on. After that, we'll take it.
Blair.
Thank you.
After 3 cross. That I am appealing for the response.
This matter is regarding just remember.
Not because the principals asked. But actual aspect is that not.
This is the stone crusher. Stone crusher.
So, regarding that confirmation has to be given and the MSP has to
I
be
was
given.
appointed on the 2002, 2004, I have to be confirmed. 2012, I will get the first MSCP. 2020, this thing was initiated against me. On the same contract, I was first.
Yes.
The factual aspect not the granting MSCP as not because it is an promotion avenue is not an MSCP has to be granted. Granting MSCP vigilance clearance is required. Moment when the MSCP posted for Lina one of the
2 months.
but the vigilance is not granting the vigilance from there. That is the
No, we cannot. This person cannot wait indefinitely for that.
You come through the order of the tribunal. I don't know.
I relied upon the
Time of this-
of single judge and division bench before the tribunal, and therefore the tribunal was convinced. It cannot be, retrospective effect cannot be given by law.
Because
And therefore,
first MSCP, the tribunal has said that first MSCP can be granted because at the time there was when we tried not to be granted, that no charge sheet was being. But when the EPC was initiated for granting MSCP.
Pending criminal cases are no longer there.
No,
It's a
but
paper.
disciplinary case is there.
Disciplinary case,
But the disciplinary
the
proceedings
proceedings
are
are
over, my
over.
lord, disciplinary case is coming, that I see, my lord. But at least, my lord, the tribunal passed the order, up to that, there is no issue, my lord.
Tribunal said that his eligibility for financial upgradation under the MSP scheme will be contingent upon the outcome of all pending criminal cases and disciplinary proceedings.
That is with regard to the second MSCP, my lord. First, the tribunal has that order. Because 2012, there was no.
Why didn't you file a contempt application with the
I
tribunal?
filed a contempt before the tribunal, that's why they have filed this writ petition.
Oh, they're there.
Notice was issued, my lord.
The
In
request is
contempt,
very
my lord, this is the order, whereby notice was issued. The moment notice was issued, they come with this application.
Under the MSCP, you said that that first MSCP was due for the period when there was no criminal.
No, 2012, my lord.
Yes.
excellent because I have gone to.
And only because contempt notice was issued, they filed this.
We'll
writ petition
dismiss
after
this writ petition immediately and direct you to do it within 3 weeks. We are giving you 3 weeks for completion of vigilance.
Let's-
No, we'll say that
This is not a party to proceedings.
who is a party. Let us see.
Yeah, correct.
Vigilance is a part of your instrumentality. Let us see.
This is to be done as per the MSCP.
So should we direct the LG? Again, you want the same repeat?
No.
We want the same repeat. Mr. Kaur, we don't want the same repeat actually. These things create unnecessary problem. So tell us who, all of you, 2, 3, 4, vigilance is done by the union government or here?
No, by the
Here.
administration, chief secretary.
So we'll direct the chief secretary to ensure, we'll use the language ensure that the vigilance is completed, it's under his control. will ensure that the vigilance is completed within 3 weeks, and within 4 weeks this MSAP is
And when
This
the
was-
case was going on that day, the disciplinary proceeding was pending. Now the disciplinary proceeding was also quashed by the CAT.
No cases.
No, I'm not on that. I say that.
Yes.
No cases. But regard to the first MSCP, that is.
No, we are directing only with regard to the first
That is
MSAP,
what
because they have
CAT
not
has
challenged,
directed.
they have
CAT
not
has
challenged the
directed.
second. So Kumar is not saying that also, the other MSAP.
So pronouncement, we can't say that,
The present appeal has been preferred by the primarily by the Andaman and Nicobar administration against a judgment of the tribunal
Page 147.
dated September 11, 2025 in OS 351 stroke 01718 stroke 2024, whereby the tribunal directed consequential benefits of first MACP to be granted to the writ petitioner stroke respondent, and with regard to the second MACP, since the writ petitioner stroke respondent was charge sheeted in the year 2020, the benefits of the second MACP shall abide by the outcome of the disciplinary stroke criminal proceedings pending against the writ petitioner. Which is the next para. Upon hearing learned counsel for the parties, we find that insofar as the first MACP benefits are concerned, at the juncture when the writ petitioner stroke respondent became entitled to the same, there was no pending criminal or disciplinary proceeding against him, and as such, the writ petitioner stroke respondent was in any event entitled to such benefit under the first MACP scheme. Which of next para, since no challenge has been preferred by the writ petitioner stroke respondent against the benefits of the second MACP abiding by the outcome of the disciplinary stroke criminal proceedings, and since we are informed that although the disciplinary proceeding has been concluded, there are still pending criminal proceedings against the respondent, we do not interfere with, we do not enter into the merits of such part of the impugned judgment. Which of next para, be that as it may, on the query of court, learned counsel appearing for the appellant submits that the first MACP benefits have not yet been disbursed in favor of the writ petitioner stroke respondent due to vigilance clearance having not yet been obtained. Which of next para, learned counsel for the writ petitioner stroke respondent argues that it is that at least 2 months have elapsed since the judgment concerned.
1 year.
Oh, 1 year. At least 1 year has elapsed after the entitlement of the writ petitioner stroke respondent accrued, and as such, the writ petitioner stroke respondent cannot wait indefinitely for such benefits to be granted, being otherwise eligible thereto. Which of next para, upon a careful consideration of the matrix of the case, the court comes to the opinion that since it is undisputed that the respondent,
Because my lord sees last second page, 2 relief was granted by the court. Last 2 lines, my lord, since my lord is right to a decision, the applicant would be entitled to be confirmed from last page, my lord, from 2004 onwards, and would also be put under old pension scheme, and then my lord this. These are 2 parts.
last sentence.
Upon careful consideration.
Score that. That was it. We also find from the impugned judgment that the applicant was held by the learned tribunal to be entitled to be confirmed from 2004 onwards and to be put under the old pension scheme, OPS category. So next para, accordingly, the court comes to the conclusion that since admittedly the petitioner stroke respondent is entitled to the benefits under the first MACP, and he should be confirmed from 2004 onwards and put under the old pension scheme, the said benefits cannot be withheld from the respondent indefinitely on the ground of pendency of vigilance clearance. Full stop, next para. we also take note of the fact that the vigilance clearance is to be obtained from one of the departments of the Andaman and Nicobar administration itself, and as such, the interdepartmental delay cannot be a ground for refusing legitimate benefits to an entitled person. Accordingly, WPCT 2022 of 2026 is dismissed on contest. The appellants are direct. The appellant number three. Appellant number 3, the chief secretary is directed to ensure that the vigilance clearance of the writ petitioner stroke respondent, the vigilance clearance process of the writ petitioner stroke respondent is concluded within an outer limit of 3 weeks from date. Next para. Upon such clearance being concluded, the appellants shall, the respondent number 5 shall disburse the benefits under the first MSCP scheme to the writ petitioner stroke respondent within a fortnight thereafter. The appellants shall also ensure, the appellant number 3 shall also ensure that the applicant stroke respondent is confirmed from 2004 onwards and put under the old pension scheme, and a written communication be made to the respondent in that regard, within 6 weeks from date. No rest of us. There is a content pending.
For the private.
That would take
That automatically it will go.
if they don't
On
comply.
that day, there was no writ petition.
No, if they don't comply still, then that order merges with this,
Yes, yes.
so that may still be maintained.
July before this.
Need not necessarily. Yeah, you can go there also. If then order merges, you can go to either.
For the petitioners, it's going to be disposed of.
Yes, Mr. Prasan.
Page 5 prior APC. Page.
You have served a notice on the other side. Mr. Kumar. That's original application is still pending.
Last 3 years it is pending. At least 19 days adjournment was.
19 to them, or you also paid for? You also must.
No. At least 10 times possibility of time.
Possibility of time is a reality. What is the stage of that? But
After
evidence
it is over. This finally is possible.
what will be a reasonable period?
Next circuit starts on 8.
Give 2 months at least. It has to be
Coming circuit, my lord,
not coming circuit. We are disposing of this, directing the tribunal to dispose it of within 2 months. 2 months.
time may not be mentioned, otherwise it won't be taken up in the next.
If you don't mention the time, it won't help you.
At the earliest,
Because
that's the purpose.
then you can never file a contempt. You should not file a contempt against the tribunal, but you can never take up before any bench. If you say earliest possible,
Earliest will be service purpose.
earliest possible is already 3 years earliest possible for the tribunal. So if you say earliest possible, it won't help you.
If lordship fixes time, then it won't be taken up in the next set. That is the difficulty.
2 months at least we should give the tribunal. We should take note of practical realities also. If you are directed by the Supreme Court,
Already 3 years over after filing.
they say 3 years are over, 2 months won't, heaven will not fall, as you say.
No, there won't be circuit. Circuit bench.
Circuit, well, the still next circuit you can mention for that.
In the month of December.
Do that.
I
You are
want
waiting for
disposal matter immediately.
2 years you are waiting.
3 years.
3 years you are waiting. So 3 months is nothing.
Well, lordship is correct, but thing is that practical difficulty is that the circuit won't be available. That is the difficulty.
Some circuit will be available in December also. Wait for 2 months or 3 months and then mention.
Kindly don't mention the day, time may not, at the earliest it will serve the purpose.
The innocuous prayer made in the repetition is early disposal of the original application hearing number 1318 of 2023, pending before the Central Administrative Tribunal, Calcutta bench, Kolkata bench, Circuit bench at Port Blair.
That explain reason the
Full stop. Learned counsel for the petitioner submits that the pleadings in the matter are complete. Full stop. Yet, the matter is pending since the last 3 years. Full stop. Next para. Although the court was minded to pass a time-bound direction on the tribunal, learned counsel for the petitioner submits that a direction for expeditious disposal would suffice, as the petitioner can mention the matter in the next circuit if it is not disposed of till then. Full stop. In view of such submissions and upon hearing learned counsel for the parties, WPCT 25 of 2026 is disposed of by directing the Central Administrative Tribunal, Kolkata bench, Circuit bench at Port Blair to dispose of original application number 1318 of 2023, pending before it as expeditiously as possible without granting any unnecessary adjournment to either party. No others to
So, sir.
So, Mr. Tabriz has so follow up the past order.
Awesome. That is first one section 4 is
Give the fight.
okay.
Lordship has affects two directions. Lordship. With regard to the 10 megawatt, it has to be extended.
Yes, yes, yes.
And with regard to the deadline, which is to be given by the commissioner, the deadline needs to be repaired before it's set.
Yes, yes.
So the bill number 9 was extended, but on the day when the matter was called, it was already approved in the client, but due to miscommunication.
No, maybe. Yeah, appreciate.
Page number 9 word, the order number 1071, dated 23rd April. It was approved for a period of 6 months.
Acha, till November,
Yes, because
till October end.
October, because there is a new set. And when that comes in.
Regarding tender, are you intending to float in a tender?
No, it is approved on.
No, this has been approved, but this cannot be a permanent
That
process.
has already been initiated. That
Tender
already
process.
So this is, as you have to.
What about the other aspect?
This other aspect, the mails and the communication which is received by the. Have been communicated, not, I have given the chart, not will come to page number 3 of the FKB. But there are 4 DG sets, which are breakdown note, appear given the.
What is the right hand column restoration? These have been restored. Right hand column says restoration.
Restoration, or it will be get repaired on that, but you will come into service because it is been repaired within this period.
Acha,
First restored for active purpose.
1st of May is only 3 days after. So it,
Should be restored because as per the communication received by the.
Mr. Tabriz, we take it on record and we'll rely on this chart as well as the economy.
That chart. Chart is just directed to followed by a coordinate section. So it is updated page number 7 of a report filed by the 3rd of September.
With regards to the DG sets.
The committee that also was there. As of now, fine, they are extended my lord till 6 months, but that's not going to permanently solve the problem. My lord. They have given a timeline, my lord, to kindly come to that. The timeline is till October, so because.
He has to put the date.
This one, this would be reply to supplementary application dated 7/8/2025 on the first page. 7/8/2025.
The report dated which one?
Sir, on the first page, 7/8/2025. The reply to supplementary affidavit
No,
Dated 7/8/2025.
last report was filed on 13th of April.
What has been directed? Those are the achievements of the timelines, my lord.
Page 7 of that reply.
My lord. As a table.
Immediately, guys. Yeah.
Administration.
Administration totally from the so that
Yes, Mr. Tabris. Those timelines they have already failed.
Failed.
Ah.
Well, they kindly come out to the next page 8.
Yes.
We'll see that the timeline what they have given is October 2026.
Hmm.
So there are certain contracts expiring in between. I respect the services my lord would be. Let them, they have extended this one for 10 members right now before Dickinson would get objective possibly till the other 1 month. The long-term program, my lord, the 50 megawatt LNG project, which is going to come up by end of 2028 or early part of 2029, which is going to be the permanent solution. So therefore, let them keep a further timeline after October also, my lord, when these tenders would expire, my lord, at least the next circuit, my lord. So what we have before this honorable court is still October. This is an extension for 6 months. We may fall back to the same place thereafter.
What do you say to that, Mr. Tabris?
Due respect for the moment when the rate petition was filed,
Yes.
But when the rate petition was filed, there was we are holding only 35 megawatt. There is a huge shortage. But now we are at 51, 52 megawatt.
Yes.
There is no deficit because there is a demand and supply is in equal. It is a balance at this position. As such, Lordship has said.
But Mr. Kumar, the difficulty is that you are going by the process of patchworking every time it's.
No, but that's why Lordship
So
has
there
said
has to be a
extend the 10 megawatt because already on 10 megawatt is.
No, you have done that. You are satisfied with that. You record of satisfaction. But regarding the other aspect, because previously a final timeline was given as October 2026. So in this reply is details of generation capacity and October 2026. The right hand column remarks is augmentation of departmental capacity. So October 2026, if it's done by that time, it's not possible probably because otherwise you would have given a report to that effect. So if it's not possible, then you also have to give a revised timeline. We'll direct that we'll keep the repetition alive so that both of you can come. I mean, you have your grievances still. This is only a patchwork for the time.
My grievance.
Your means plural, not Mr. Tabris. Obviously, you are representing the islanders. Your means not your client also. Your means in plural. This is a public interest litigation in any event. So your means all.
Yes.
We'll keep it on record. We'll direct you, Mr. Kumar, to file a further report as to what will be the extent timeline and what do you propose to do regarding the other contracts which will be expiring prior to this timeline, whatever timeline you give. So there will be a composite report. We'll direct this to appear in the next step, and we'll accept this for the time.
Thank you.
And regarding solar panel, your defense was that they can use solar panel. Now, please tell us, Mr. Kumar, enlighten us on this, whether you are to provide some infrastructure or to give some permission because overnight it's not possible for all the islanders to
It's.
Your cooperation in that regard is also, you can take recourse to that also.
Student engineer is such she can analyze.
She'll be in a much better position to enlighten than either of us. So ask her and tell me, to tell us, sorry. Ask her and tell us.
Both are.
No, just ask her whether there is any scheme in on the.
There are schemes, my lord, but those we can't compel the consumer. It's their choice whether they want to take it or not take it. There are subsidies there, but everybody is not voluntary. Because that will not work out during the monsoon.
These are general, but what is the administration doing on these?
We have,
We see the photograph everywhere, but we want your investment.
No, not you, but
We are not interested in the photograph of the Honorable Prime Minister. We are interested in what you are doing. The administration. These yojanas have to be implemented by you. You are implementing. You will say something, ma'am. Yes, you can, please. Use the microphone, please. Yes.
So now,
Absolutely, please.
like to submit, sir, this is a very ambitious scheme, sir, but in these islands, sir, apart from the subsidy that is given by government of India, that subsidy is limited to 33,000 per month, whereas for other states and UTs, sir, it is only 30,000. The CFA, Central Financial Assistance. Sir, your UT administration has gone a step ahead, and we are releasing around 45,000 subsidies, sir, over and above the 33,000 subsidy.
Another question to you. We understand you are doing your best. The other question is whether during the monsoons this will work, the solar panels. We are not sure about the technology.
Sir, I have also implemented in my house, sir. We get a benefit from two accounts, sir. One is the reduction in the energy bill, sir, which is there. We get around 3 to 4 units per day, sir. I have installed in my
During the
house.
monsoons also you get it.
Even during the monsoon, sir, because there is a diffuse generation. There is a misconception, sir, that during the monsoon it doesn't work.
All right.
But it works, sir.
So there is
it may be
a
less.
process of conserving that in some form. Electricity, can it be conserved?
Sir, it can be conserved also in the battery. If the consumer is adding battery to the project, it can be also used during the evening hours.
But that can be at least an inducement, but that cannot be the mode of choice, may not be the mode of choice for many people.
So many of the consumer already have the inverters in their house, or ordinary inverters, which has a battery. The same battery can be connected to the system and they can store the power. And apart from that, sir, we are also implementing a battery project, sir, which will be a pool best for all these such kind of powers that come from the consumer and which is surplus, which is, sir, in the tender state, we have already tendered and we have got vendors also for that, sir.
So you have a role to help the islanders on that. I mean,
yes, sir.
you will also do a part of the project of establishing these things, or they will have to do it of their own.
So the vendors have been identified, sir, so that they can only select the vendor, and once the plant is installed, the subsidy is released within 7 to 8 days by MNRE, and by us, by the UT within 15 days. So the captive investment that the consumer takes.
So that is your defense also. That was your defense also for not doing this. That they can move on to solar plants.
They can move on to solar.
We'll record that, but we'll also record Mr. Tabriz's argument that it's a choice of it has to be decided whether it's a choice of the consumer. We'll keep that open, we'll keep the petition pending, we'll record your submission on this. And we'll say that these have been supplied by you, we'll keep these on record.
Sir, is
Right? Can we keep these on record?
sir, the second one, sir, which doesn't have, we don't want to announce the second one.
So definitely. So you're right.
slightly add this happening in the solar.
Yes. It affects.
Subject to what little information.
Only this we are keeping, yes. Yes.
Subject to what.
You understand the reason also. Yes.
Subject to what little information I gather, the administration measure they are having solar outside, which subject to correction, which is possibly has a capacity to generate about 4 to 5 megawatts of electricity.
No, they're giving inducements to you to yourself set up.
That's the other thing. That's another project. But apart from that, administration is running and operating a solar-based power plant having a capacity of 4 to 5 megawatts subject to correction.
That would not suffice.
That would not suffice. There are two issues there. Now, during summers, it's generating substantial quantity of electricity. Now, there is no battery backup over there. But when this power is generated, surplus has to be held somewhere. As of now, there is no battery backup. Moment there is a cloud formation, immediately.
As of now, there is no battery backup. Means if they are identifying vendors,
No,
and then
this
we'll
is
also have the
separate.
battery backup.
For a particular solar plant.
No, we are not interested in that. That is the administration has that. But they're inducing the citizens to do that. So that's a different prospect
That's
altogether.
going to be a voluntary act of whether somebody wants it or not. But
That question will keep open whether the administration has a discretion to.
that will not lower the burden of the administration for performing their duties.
A report in the form of an affidavit. A report in the form of an affidavit is filed today by the respondent's administration as per previous direction of the court. Which of next para from the same comma it transpires, which was the page that wanted extension. No. Oh, sorry. Comma that video order number 1071 dated April 23, 2026, comma administrative approval and expenditure sanction was accorded for an amount of rupees 1,71,05,400 oblique dash for procurement of 5 MW during peak hours and 4 to 5 MW during non-peak hours on nomination basis in line with the willingness submitted by one Messrs. Express Gensets Consortium Private Limited within bracket negotiated willingness bracket closed to supply power at 86 paisa per unit and SFC 3.7 units per liter for a period of 6 months with effect from May 1, 2026. Full stop next para. Thus, comma, the court is satisfied that for the present, comma, the contract which was going to expire has been extended for a limited period of 6 months starting from May 1, 2026. Full stop next para. On the larger issue of the steps being taken by the administration to revamp the infrastructure and the department and to augment the departmental capacity to cater to the electricity needs of all the islanders, comma, learned counsel for the respondents places reliance on a chart given at page 3 of the present report, which indicates that the repair work and restoration of the damaged stroke worn out equipment has been formulated and the timelines scheduled therefore are given in the chart. First up, next para. Learned counsel appearing for the petitioner submits that the stopgap measures would not suffice and the administration ought to give a firm timeline, comma, since they have already jumped the previous timeline given, that is October 2026, comma, within which period it does not seem possible for the augmentation of department capacity to be concluded. Full stop next para. Thus, comma, learned counsel submits that the islanders want an assurance of the revised timeline within which the entire augmentation shall be positively done. Full stop next para. Learned counsel for the respondents, comma, on instruction of the engineer who is present in court today, comma, hands over a brochure from which it is indicated that subsidies are given for setting up solar panels by the individual islanders for the purpose of catering to their electricity needs. The engineer, comma, personally apprises the court with leave of court to the effect that the subsidies given by the central government to the tune of rupees 33,000 is higher than subsidies given in general to other parts of the country. Because of that apart, comma, it is submitted that the island administration, comma, of their own, comma, are giving an increased subsidy of rupees 45,000. Of rupees 45,000. Full stop. Next para. To this, learned counsel for the petitioner argues that the use of solar panels as an alternative source of electricity depends on the individual choice of the islanders and cannot be thrust upon them or used as a defense by the administration to resist the augmentation of the infrastructure to cater to electricity needs of the islanders through the mainstream mode. Full stop. Next para. Be that as it may, the last above mentioned question is kept open for being decided finally in the repetition. So for the present, we find that since the extension referred to above has already been granted for a limited period, no issue remains on such score. So next para. However, the more fundamental issue as to an assured timeline for completion of the augmentation of the entire project still remains. Moreover, since other contracts would be expiring before the same period, the court requires a specific assurance on the part of the administration as to what steps they are contemplating regarding either extension of those or for completion of the tender process to give new tenders. So next para. Hence, the respondents are directed. Which respondent should we direct? A particular respondent number? 4.
Commissioner comes in. He has filed this.
4. Hence, we direct the respondent number 4 to furnish a further report indicating clearly as to the revised timeline which the administration proposes for completion of the augmentation work of the departmental capacity to meet the electricity needs of the islanders comprehensively. So next para. Secondly, the same further report shall also disclose as to what plan the administration has for issuance of for completion of tender process, alternatively for extending the existing contracts from time to time till such augmentation is complete. So next para. Such further report shall be filed in the form of an affidavit on the returnable date before the next circuit. Full stop. The brochure and the report in the form of affidavit filed today are kept on record. Full stop. The repetition shall next be listed for passing further orders on the before the division bench in the next circuit. An advance copy of the further report shall be handed over to the learned advocate on record for the petitioner in the meantime.
Every time it's been given.
My lord has given
No.
deadline.
Now my lord has indicated.
Indicated the time. And 40 minutes. Otherwise, I would have been given so that I don't read.
No, he even he himself didn't read.
Right.
Thanks, sir. এবার আমাকে ইনজাংশন পাস করে দিলে রসগোল্লা বন্ধ করবে আর কি দেখাচ্ছে কি হয়েছে আর কিছু নেই নষ্ট করে দেখছি Yes, sir.
In fact, my lord has passed an order. My lord can see that.
Lord has asked us, see whether any vacancy was available, PTT Bengali. Not done.
Very well.
I taken shift from.
Yes.
With regard to the post is not required this because as per the requirement of PTT arts, it includes Bengali and other various. But particularly the PTT Bengali, whenever the vacancy comes, based on the requirement, the vacancy will
We must have a list when it will arise because the tenure of the earlier person is over, or we should have a plan on that.
earlier, it is requirement with this, we have advertised and that post has been filled up. But Lord, we have.
No, you must have a timeline when they will retire.
My lord, I have the document obtained under right. to
Just
Information
see.
Act, and I have supplied a copy to my lender friend day before
You're
yesterday.
giving under right to information act, but not giving to them.
I showed it to this because Mr.
My lord, kindly see page number 1. First para, my lord, this says provide certificate copy of details showing the total number of government schools. That is 39. Bengali medium is 15, my lord. Now, my lord, we kindly come to third page, my lord. Here, if my lord sees at the right hand side, annexure A, left hand side, PGT Bengali vacant post 9. At the left hand side bottom, 9. And my lord,
Left hand side or right hand side?
left hand side. Third paper, third page, my lord.
Third page is this.
Yes, my lord. At the left hand side, if my lord sees, serial number 21,
Oh, yes. Vegetable. Yes.
vacant post 9. Now, my lord, we find at the right hand side, detail of vacancy, number of posts. My lord, this was the advertisement in which I have applied, my lord. That also has been disclosed here, that advertisement, my lord, which I have applied, wherein my lord will get at serial number 3, Bengali language 1. Now, my lord, may kindly come to the next page is the provisional station seniority list of PG Bengali. That is not required, my lord. And thereafter, my lord, total number of persons holding the post of Hindi, Bengali, English, everything. Relevant would be, my lord, last page, my lord. PGT Bengali teacher at the top. It says total number of schools 16. PGT Bengali. Now, my lord, these are the persons who were appointed, even the incumbent whose appointment is under challenge. Sanju Chakravarti, his name is also there, my lord. And my lord will find Subodh son, Lakshman Haldar, both retired in the year 2022 and 2023. Aparna Chakravarti retired on 18th of January 2024, much after the said advertisement, my lord. So from this, if we go, my lord, we will find altogether 11 names are there. Out of 11, my lord, 3 retired from service.
So at least 3 more are there.
3, yes, my lord. 11, if we see only 9 posts are there. If 3 go, my lord, at least 1 post is lying vacant, my lord.
Why 1 post?
Because, my lord, it's Sanju Chakravarti, my lord.
Sanju Chakravarti holds 1.
Yes, total post is 9, my lord.
Oh, yes,
is
right,
9.
right.
So those 2, if goes, there are altogether 3 persons, 3 posts are lying vacant out of 11. And in that case, also 1 post is still lying vacant. Now, if my lender friend, because I have served an advance copy to assess.
What was your grievance, original grievance in the petition? What has the tribunal done?
My grievances was that, my lord, they say that I was overage. Certain circular was issued by the administration. They said that those circular is not available to me. Tribunal held that those circular are available to me. And the exception itself, tribunal has passed an interim order.
Those relaxed the age.
Subject to abide by the. I participated in this election process.
No, you are overage, they're saying.
Overage. I applied, my lord. Applied only on the ground that I am overage and my candidature was negated. I challenged it before the tribunal and I also filed.
Tribunal directed them to appoint you subject to result.
Tribunal held everything in my favor. Subsequently, the tribunal says consider it. I said
no. What did the tribunal hold in your favor? That you are not overage at the relevant point.
That office memorandum is applicable and I am entitled for age relaxation.
That is what we are saying. So age relaxation is the
yes.
Unless it is relaxed, you cannot.
Yes.
So it was held in your favor.
Yes.
But what was not held in your favor? That's subject to.
The court said
Consider. You say direct.
Yes. I said direct because there was an entry
point. And Mr. Kumar took a point that there may not be vacancies.
May not be vacancy. And my lord, that person was appointed in his appointment order in his offer of appointment categorically. It was written abide by the result. Now, my lord, I have shown 3 orders of this court also. My lord has on the last occasion, my lord has made an elaborate recording of the facts, my lord.
So the tribunal, it is still pending before the tribunal.
Yes, of course.
So what abide by result of this writ petition we are there?
No. The tribunal at the very exception when I moved the.
Oh, achha. Say Sanju's appointment will abide by that.
At that point of time, they could
So
not have appointed.
now we are trying to explore an option whether without removing Sanju it can be done.
Yes, that is what my lords were considering, my lord.
Yes, so there is one vacant as per your last page.
Also required to be as a professional, also be training, also be there. But my humble submission is in terms of the order passed to the tribunal, in order to see our compliance, we have specifically mentioned the OAL and said that the appointment given to who are, because it is a combined appointment, abide with the result of the OAL.
Mr. Sanju's appointment.
It is specifically mentioned on the case number and.
It is right.
But my humble submission is the moment when advertisement passed, the 8 factors which is she has holding that, because in terms of 2011 notification, whether he is eligible to be granted age election or not, that has not been decided at that point of time. So he is found to be ineligible. And after that, an order passed by the tribunal on certificate, the administration is also found the circular that age election should be granted to the guest lecturers, those who are working in JNR. Because the circular that was not reflected at earlier point of time. The tribunal, when dealing with the issue, the tribunal has said because you, based on the age election, should be granted to the guest lecturer in terms of the earlier order passed by the tribunal. But the tribunal has said if it is no post is available, then the next recruitment she also to be entitled to get age election. I'm sorry. He also required to grant age election. Next, if any next available vacancy, next recruitment has been done. But the tribunal order is in reasonable if it's substitute to tribunal.
You have challenged that also.
They have not challenged.
We have also
They have only challenged
Yes.
part of the order. No,
We
they
have
have challenged
Which
this part. They have not challenged. The tribunal.
Let him complete.
Yes.
There are 2 aspects of the order of tribunal. Lord, we kindly come page number 200 of the record scheme. With regard to para 10 and para 11. The tribunal in para 10, the tribunal has said that the.
Oh, 0.2
2 marks.
That has become irrelevant because
Yes, I scored 4 marks.
I understand, but it will be as an legal order, it will create for issue because guest faculty is not to be treated as working on the 8 hours because the tribunals are behind your consent. We are not denied it. Not, I just show only one our reply. If not, thinks it's appropriate, you will pass this. Not will kindly come to.
no, he has got 0.1.
No, we say he's entitled to 0.1. If he has granted 0.1 because as a part-time guest.
That portion is not this.
But the tribunal says he's entitled for 0.1. That we have challenged.
So that becomes academic
Academic.
in the sense that if it depends on the age relaxation.
Yes.
So let us forget that.
Part, not with regard to 11, the tribunal has.
See, if there is a vacancy, we find from the RTI.
Vacancy is not as per my instruction, they say that vacancy must be based on the requirement basis, the vacancy will, because the RS says PGT. It is not PGT, Bengali PGT, Tamil PGT. But if required comes.
Even on the requirement basis, there is one vacancy as per your RTI. Mr. Kumar, we cannot dispose this side. So we'll ask you to file this in the form of an affidavit annexing this, that you have obtained this from them. And Mr. Kumar will give you, yes, a response to this. So in that, we'll clarify that not only response to this, you will also clarify the modality in which what you are saying verbal. That has to be clarified, and you have to clearly disclose as of present whether there is any vacancy, even on that modality. Because we take note of this. We'll keep this on record, but you have another copy, must be.
And I have added on one copy.
Yes, better because Mr. Kumar can take instruction. Learned counsel for the petitioner contends that in terms of the improved judgment of the tribunal, despite having held all issues in favor of the petitioner, who applied for appointment as a guest lecturer in the Bengali language, the learned tribunal merely directed the respondent authorities to consider the case of the applicant for appointment against the post of PGT, Bengali, after granting age relaxation in terms of the circulars dated September 19, 2011 and October 20, 2022. Next para. It is submitted that instead of leaving it further on the respondents to undertake the exercise of consideration, a clear direction ought to have been passed to take the present petition in the available vacant post, where, in the meantime, one Sanju Chakraborty has been appointed. Next para, the counsel for the petitioner further submits that it was clarified at an earlier stage by the tribunal that any appointment, if effected in the meantime, shall abide by the outcome of the original application. So, as such, since all issues were decided in favor of the petitioner, there is no further scope of the administration arguing that the said Sanju Chakraborty shall be retrenched in the event the petitioner is accommodated in the said post. So next para, we are further apprised from the records that at the time of giving appointment to Sanju Chakraborty, it was categorically mentioned in the appointment offer, which was clearly accepted by Sanju Chakraborty on all the yardsticks thereof, mentioning that the appointment of Mr. Sanju Chakraborty would abide by the outcome of the tribunal's order. Full stop. Hence, there would not have been any issue in that regard otherwise. Full stop. Next para. However, to explore other options to save the said Sanju Chakraborty from being retrenched, if possible, the court had requested learned counsel for the respondent's administration to apprise the court as to whether there is any existing vacancy in the post of PGT Bengal. To the next para, learned counsel for the respondent authorities submits that the appointments are done not specifically for particular subjects, but as a cumulative process for all PGTs. The vacancies in respect of particular languages, including Bengali, arise on occasion basis. Next para. Since such modality is not clear to us, we direct the respondent's administration in WPCT 8 of 2025 to furnish a clear report in the form of an affidavit as to the exact modality of appointment in the post of PGT Bengali and as to the manner in which the vacancies for the said post arise. Next para. We further take note of the fact that the counsel for the petitioner has handed over an information apparently obtained under the Right to Information Act, which indicates that there should at least be one vacancy in the post of PGT Bengali, even after having given appointment to Sanju Chakraborty in view of the retirement of 3 others out of the total 11. Next para. A copy thereof has also been handed over to the learned advocate for the respondent authorities. Next para. The petitioner in WPCT 8 of 2025 is directed to file such information by way of an affidavit within a week from date upon giving an advance copy of the same to the learned advocate for the respondent's administration. Next para. In addition to the report as directed above, the respondent administration shall also file a response to the said affidavit filed by the petitioner, clearly indicating as to what are the current vacancies as of today in the post of PGT Bengal. Such affidavit and such a report in the form of affidavit as well as response shall be filed within a week after filing of the petition by the petitioner. Next para. Such pleadings shall be filed before the shall be submitted before the appropriate bench in the next circuit when the matter is next taken up for hearing. We direct the matter to be listed in the second week of the next circuit before the appropriate division bench, subject to the subject to being so permitted by the said bench. Yes, please.
I applied for the post of PGT Bengali.
Yes, let's do this. guest lecturer, assuming that it's.
But sir, there is only one vacancy in respect of that unreserved category, not in respect of the other. So that needs to be, I think, so. And he's unreserved. But this one,
There is only one course.
but in respect of the others, like Bengali medium economics, that is not to be taken into account. Only PGT Bengali. So there is only one vacancy and that too unreserved.
I think the answer is
Recorded. So, okay. Did it. ওটাই বলছি তুমি ওরা না শেষ হয়ে যায় চলে
I can invite it. You said 400.
ঠিক আছে supplementary list has been public. That has been published. Yes.
If I undertake to fight for that now, we have one.
At the admission stage, you don't have any right of hearing. They will first hearing. If you admit the appeal, only then you will hear. Yes. Order of Rule 11 does not give you a right of hearing.
Consented in.
Yes. Please take your seat. Thank you. Yes.
There is no dispute that it's a consent. After consent decree, preliminary decree was passed, this court appointed the Tahsildar
Citizen.
and partition commissioner, any partition was submitted to him. The submergible land, rainy, dry season there will be no problem. The rainy season, the land which was allocated to me in the report.
Can the consent decree be challenged?
I am challenging the report of the commissioner.
You cannot challenge a report in isolation in an appeal.
First report I have challenged,
Now, the section 5 was allowed.
no. I have directed to start.
Leave and section 5. What is the ground in section 5?
18 days delay. My client.
Section 5 you are condoning and dismissing the second appeal. What report you are challenging? Report was a part of the records in the trial.
Challenging the order judgment and decree passed by the first appellate.
No, this consensus was arrived at the first appellate stage. The consent decree was passed by the first appellate court,
No,
by the trial court.
no.
You put an appeal against that was entertained also, or it was dismissed on that ground.
Was dismissed on the ground that the second commissioner report accepted by my client.
Dismissed on what ground?
Dismissed on the ground that second commissioner report, my landed, Astro landed at all, accepted the second commissioner. First commissioner report was denied. Thereafter, advocate commissioner was appointed.
Yes.
He submitted the report. That report is nothing but the replica of the first report. I would have challenged that report also because there is no changes in the second report. But without my consent, my landed advocate accepted the report and final decree has been passed. That final decree challenged before the first appellate court, dismissed the appeal on the ground that my landed advocate already accepted the second commissioner.
First. The appeal itself was not maintainable against the consent decree. There was a scope of filing a second or first report. The first report was filed in the trial court.
Second report also.
Filed in the trial. This appeal could not have been entertained even. So it has been dismissed. Rightly, we'll say that it was rightly dismissed, but on grounds which it should not have entered into the merits. But on principle, we are affirming it because we are not entertaining a second appeal because it was against the consent decree. It did not lie even.
What I found that it does not say it's a consent decree. Just
Does not
next
say.
party. Page number 13 may see my stay application. That is should be the same is decreed in preliminary form, but expertise has to be defended, but without any order. It won't filed by the expert.
Oh,
File here.
The consent was only regarding this acceptance of report.
Acceptance of commissioner report.
Then it's not against the consent decree. This is not called a consent decree. Please take your seat. You don't have a right of hearing. You had preferred this appeal. You had preferred this appeal. You do not dispute the shares.
I am not disputing this here. My only contention is that the first commissioner report, the low land.
No,
which is
commissioner's report means, I mean, this was a preferred against a preliminary decree or a final decree.
And
Final decree. That's why the commissioner's report becomes important. So that the commissioner's report was accepted and the final decree was passed expertly.
have challenged the final decree. The first.
Final. Commission's objection to this. No, the court records at page 8, after hearing both sides, of the case and recording their satisfaction with regard to the partition, report was accepted. So you say expert degree, preliminary degree was expert.
Yes.
Final degree was not expert.
No, final decree.
You are challenging the final. Why did you say expert?
Final decree was challenged before the first appellate court.
The commissioner's report was accepted by the advocate, your advocate.
That is my case. That first commissioner report I have refused. I have objected because of the rural and the suburban land were calculated. That the first commissioner report was rejected by the trial. And thereafter, advocate commissioner was appointed. And advocate commissioner submitted the report, the same report, similar report. There is no change. And without my consent, my land advocate accepted this.
The first report, you had objected to that first report.
Yes, that was rejected by the trial. That was rejected, and thereafter advocate commissioner was appointed as the second commissioner. And he submitted
It is recorded that the report and the sketchwork were accepted by consent.
the second report. First report was denied.
We are speaking of the second report. That was the final report.
That is my contention is that without my consent, if there is any changes in the first report and second report, I can understand. But
So can you show us?
exactly the same report.
Can you
was
show us
submitted.
the final degree of the trial court? The reports were filed all in the trial court.
Yes, yes,
So we want to see the final degree of the trial.
Page number 33 of the stay appeal.
Achha, here they don't insist. You have to also file a certified copy of the trial court judgment also. Our rules say that you also have to file otherwise it's a defective appeal. You have filed the trial court also. No, it's not there in memorandum itself. It has to be there. You have filed that also. Then we'll see the from the memorandum.
Having this stay application.
So we are having everything. Yes, it is there. So why are you showing us from that? We'll see from the original certificate copy. It's dated 8th of December 2016.
What product?
No, that was the preliminary decree.
Final decree.
Yes.
8 December is the final decree. 8 December. That's final decree.
No, final decree
Final
March
decree.
March 22nd, 2018.
Let me look at it.
Where is the judgment? Find the decree, but where is the judgment? Appeal court judgment is there. Where is the order recording that consent and everything of the trial court? That judgment is also recorded here. Annexed only the decree certificate
No, separate judgment has been passed.
has to
After
be.
accepting the,
Decree cannot be drawn out. That acceptance has to be by an order.
that order is there.
Where is that? You don't find it. Certified copies. We don't find that. Yes. No. Preliminary decree, the judgment is there. Find the order of the order accepting the commission of it. There only the consent must have been recorded. To annex that. Preliminary decree is we find. The judgment is also there, the decree is also there. Decree cannot be drawn up unless there is a supporting order. There cannot be a standalone decree.
Order was passed.
Where is the order? We have to annex the certificate copy of that. That is the most important thing here. That is the most important thing here.
It is there in the final decree also, it is mentioned in the final decree.
Anyway, let us see the final decree. It is ordered henceforth all 5 shares. Where is the consent recorded? Yes, does not raise any objection. No, does not say that. Let us come to the final decree of the trial court. Please read it out. Henceforth, all 5 shareholders of the land will get.
Because all 5 shareholders of the land will get equal share of the land from the survey number 59 and 53 of the land as per the colored map submitted by the learned advocate commissioner along with index annexed to
This consent and everything is not written. It must be there in the order. The judgment. Where is that? File a certificate copy. We are allowing the section 5. We directed to file a certificate copy of the judgment supporting the final decree.
that order. But order has to be passed by them.
We'll write judgment stroke order because if it's. Acha, we are hearing you on this section 5. 18 days delay, we are allowing it.
I undertake to file memorandum on behalf of.
We'll record that also.
145.
What is the reason for the delay?
My friend forgot to get the certified copy of the transfer.
Yes. Upon being we order not really constantly. Upon perusing the application bearing Can 2 of 2026, we find that sufficient explanation for the delay in preparing the appeal has been made out. So upon hearing learned counsel for the parties and upon going through the pleadings in the condonation application, Can 2 of 2026 is allowed, thereby condoning the delay in preferring SAT 4 of 2026. So next para, no orders to costs. Subsequent para, at the time of hearing under order for 211 of the Code of Civil Procedure, we find that the judgment stroke order preceding the final degree passed by the trial court has not been filed, nor has any certified copy thereof been appended to the memorandum of appeal. Since the print of the arguments of the appellant are based on an alleged consent given to the commissioner's final partition commissioner's report having not been given by the appellant but by his advocate, the certified copy of the said judgment stroke order becomes absolutely necessary. even at the stage of hearing under order of Rule 11 of the court. So accordingly, the appellants there. Accordingly, the appellants are directed to file the certified copy of the judgment stroke order preceding the final decree passed by the trial court within a fortnight from date. First of next para, let the matter be listed under the heading order for Rule 11 before the appropriate bench in the next second. First of next para, on the prayer of learned advocate having instruction to appear for all the respondents.
No, 1, 4, 5 and 6.
Respondent numbers 1, 4, 5 and 6, comma, leave is granted. For them, the others have to be served. Section 5 has to be served.
Right, already.
Fine. Leave is granted to the learned advocate. What is your full name? Your full name. Yours.
Siddharth Singh.
Mr. Singh. On the prayer of Mr. Singh, comma, having instruction to appear for respondent numbers.
No.
Comma, leave is granted to Mr. Singh to file his Vakalatnama on behalf of the said respondents by today.
2 days.
Within April 29, 2026 in the department. Section 5, first add something. From the affidavit of service, it transpires that all the respondents have been served. So as such, we take up the combination application for here.
That's a very good point.
But he has got a good point otherwise for admission. You are lucky that we are not taking up for admission.
One doubt. If something is asked from the court, if I have that document, then I should.
At the order for Rule 11 stage, we are clearing that down because we don't have anything personal against you. Rather, we like you, like your appearance, your arguments. Order for Rule 11, see the language. It says upon hearing learned advocate for the appellant or the appellant. That has been interpreted by several judgments of our court. I don't remember by memory. There are judgments which say the respondent does not have a right of hearing. Some judgments say even respondent cannot be heard. We have some doubt regarding this extreme proposition. If the court feels that some clarification is required and the respondent is present, some courts take the view that the respondent court, if the court wants, court can seek a clarification. But at the juncture of order for hearing admission, actually it's not an admission hearing. Order for Rule 11 languages shall dismiss if no substantial question of law is involved. Admission is basically under Rule 13, which says notice to be served. So under order for Rule 11, only upon hearing appellant, if court feels substantial question of law, then it is admitted. That's why you don't have a right of hearing.
Right.
Otherwise, what will happen at the admission stage, there will be a full-fledged hearing. You will argue, they will argue. Then nothing will remain in the final hearing. That is the principle behind order for Rule 11. You are clear now? Nothing personal against
Yes,
it.
yes. Not if I ask for that certified copy, that certified copy comes, that one paragraph is.
That one paragraph is the most important,
Yes, yes.
crucial thing here.
Yes.
Has been purchased.
Something good for
Support. Please call. Oh, we gave 144. Request and just confirm.
Look, page 16. 2 years back in 2024, this petitioner was granted bail. But the offense was.
Is Zinu is appearing for the other side?
Right.
You are.
At that time, Ms. Zinu was in the prosecutor's.
No, our officer was covering Mr. Karmuk.
So at page 16, your lordship will get the original order, June 20th, 2024. This was a case under the Official Secrets Act. This petitioner was a seaman. He comes from UP. He was working on a Navy ship. Never may recall this matter. The lordship had heard. Then while he was doing that, he was getting calls and messages through Facebook from a 16-year-old girl who was enticing him. That 16-year-old girl turned out to be a 70-year-old Pakistani spy.
Oh, yes. We impose very stringent conditions.
It's significant. Now, the conditions are at page 20. Now, the second condition was shall not leave the territorial jurisdiction of the trial court throughout the period of trial, which means even the learned court below cannot hear anything with regard to my leaving.
This is clause.
Number 2, number 2 at page 20.
Shall not leave the territory throughout the period of trial.
That was the first, very stringent condition. The
Yes.
next one is 3, report to SHO once in a week, disclosing his details of whereabouts and each activity. 4, shall not in any manner engage in social media communication on any social media platform throughout the trial. 5, police are liberty to monitor the entire activity, etc. Then 6 and 7 are definitely required. Now, a few months after that,
Give us
Ma'am,
some. Sorry, please.
But now thereafter, after a few months, page 22, your lordship will get.
Yes.
This man's mother, her kidneys failed and she was on dialysis.
So video call and phone call was permitted.
No, not phone call even, not even video call. I was told when I go for my weekly visit to the SHO will use his phone to make a video call. And in the SHO's presence and monitored by him, I can talk to my mother once a week. But I have no access to the family otherwise. Now what has happened is, yesterday, page 24, yesterday she has fallen down. This is today's 27, yesterday. She has fallen down and broken her pelvis. My lord will see the left at the bottom, fracture of the left pelvis perceived, and she has been advised for emergency surgery. That portion on the left. And
Yes.
the earlier documents of 2024 have also an abundant caution. That is at page 25.
She is a resident of UP.
UP, Deoria district under police station Patpad Rani. Now, my lord, I have been attending every week religiously. I have the records with me for the last 3 years. I have not violated any condition. Now, the reason why the division bench in November did not want to relax my condition is because your lordships had said throughout the trial, and my learned friends had said that one witness has been examined, there are 19 more, we'll finish it. And as of now, 2 witnesses have been examined. So there are still 17 or 18 witnesses to go. There is no chance of this trial completing. And my lord, with the greatest of respect, may I say this, I'm in a situation where I am under constant monitoring and surveillance. I have no access to my family in the last 3 years. My mother is now in a state of extremes. I am willing to submit to any conditions. My lord, if it commends your lordship to.
The difficulty, Mr. David, is not about you, but with the charges leveled against you. It's very serious.
My lord, with the
These are exceptional clauses which we put
with
in.
the greatest of respect,
normally
may I say this, the law doesn't say this is very serious. For the simple reason that these are magistrate tribunal offences. Not even sessions tribunal.
No, the security of the country was compromised. That was the allegation.
Kindly remember the allegations that someone on Facebook, a young girl, is messaging me and I'm saying this ship came into the dock, this submarine sailed out of the dock. That's all.
What is the reason of disclosing the whereabouts of the ships? If you have a girlfriend,
this was a
be
young
married
boy.
with her. But why?
This boy was a young boy. He was trying to impress this girl by saying, I work in the Navy. I had argued at that point in time, your lordships, if I stand with a pair of binoculars on the marina, I can see all the Navy ships coming in. There is no intention shown that this boy knew he was talking to a Pakistani spy. He was simply trying to impress a young girl on the internet.
That is your case, Mr.
Well, that is
We
true,
need
but
to be exploring examining the.
True, but my only submission
It's
is
sufficient for you to share the details of ships. Which ship? What are the details? Why?
what were the details? Only the
Which girlfriends asked about ships and particulars and when the ships leave. Young boys have much more other interesting issues to talk about. Which ship is leaving, when it leaves the dock, when it comes in.
Perhaps this
Can you imagine a boy speaking about these things only with his girlfriend? I cannot imagine. You lack imagination. For that, you should be kept in jail.
With the greatest of respect, man, this boy is a young village boy from UP. He
Understood.
was working on a Navy ship in Andamans. He was trying to show. That was about it. The question is,
You cannot revisit that. But your mother's condition, have you did anything besides Kabir, that who are the other family members, whether there is anyone else?
no, man, I don't even have the instructions. This boy is there, but he clearly is.
No, you must know who else is in your family.
No, no,
So why should
there are other-
you be?
I have not pleaded that there are other father-in-law are there, but it is my emotional anguish that now for 3 years.
So what
I've been away from my family.
relaxation do you want? You want to go there?
If there are 2 things that can be done. One is if your lordship permits me to go, I will satisfy the trial court.
Mr. Kabir, move it before the next circuit.
May I say this?
Don't take a chance before us.
Three things. May I just make three humble submissions and I leave it?
We'll give you a liberty to use a supplementary activity disclosing the composition of your family.
Three things. Number one, the extreme would be if your lordship permits me to go, I can report to the SHO there each and every day. It's being done in other serious cases of murder and unrepentant.
Murder is on a different footing.
No,
Murder happened in a particular place. You have murdered a person there. To go there, we can understand that.
No,
But going from here to UP, who will accompany you?
But I will report to the SHO there as soon as I reach
If you jump in, what will be the protection of the, I mean, what, not the protection, the reverse. What will be the sanction against you? You can just leave here and just flee.
So that is the undertaking that is being given before the court.
That undertaking, your undertaking cannot be taken at this stage.
The second option is if your lordship would be pleased to say that let at least the trial judge consider this. That I satisfy the trial judge rather than my coming to the High Court. If your lordship relaxes that.
If once we don't grant Mr. Kabir to serious thing, the trial judge will give it.
No, if your lordship
He
says.
can say that.
If your lordship's original finding that throughout the trial he must stay in the islands, if that is watered down, then that liberty is given to me to move before the trial judge and satisfy it. Then I'll go, I'll come back. I do not have high hopes of getting that order, but that's a different issue. But at least I can
So
try.
2 has to be modified then, which says that you cannot leave the trade. And what else? And the regular reporting.
No, 2 modified. Regular reporting is not required now that I'm going every week. Now the trial is not in full swing, but it has started. Even so far as 3 and 4 are concerned, I'm not even using a smartphone because your lordship said no social media communication of any sort.
Yes, we were very pained to pass this order on a young boy, but we had to do it.
No, I appreciate it.
According to our.
And may I say
judicial
that when we come for bail,
sometimes
we say we will adhere to all conditions.
Sometimes conscience and judicial conscience have a conflict,
Accept that.
and judicial conscience
I
prevails
accept
over
that.
our own conscience.
I hate to make the next submission. When we come, we do acrobatics for bail. We say we will abide by all conditions. But your lordship should
We are not saying that even.
My lord will consider the law has changed since then. The Supreme Court now, after various judges, Frank Whitener says you can't do geo-pinning, geolocation. There are judgments.
We are saying that you can't.
Bail should not be.
We have not directed you to be tracked. That's why we have kept you here.
No, but the fact that I can't contact my family without monitoring by the SHO's phone, that is my right to privacy, the right to family. There are other rights inbuilt into Article 21 apart from only the right to personal liberty.
Subject to certain reasonable.
My lord, here if your lordship considers.
Otherwise, the capital punishment would be.
The value of the bail order has to be something that allows me to enjoy my liberty. If my liberty itself is as bad as incarceration, then the very purpose of liberty fails. My lord, sir, kindly not take me amiss, but we are.
Surrender and be behind the bars.
No, man. That is what I said. Kindly don't take me amiss. The
Sir,
bail is a privilege I'm enjoying.
Your privilege is only to breathe in free air.
My lord, but
that free air is restricted severely. That free air won't include
that I understand.
internet connectivity.
The thing is to access, even if I can make WhatsApp calls to my family through video, I will not use Facebook and social media with strangers.
WhatsApp call to your family has been permitted through the SHOs.
My lord, once a week I can talk to my mother through the SHO's phone. There's no privacy. There is nothing.
If you are at home, how frequently would you talk with your mother?
My lord,
Please.
at least I can communicate with the family.
Please. If you are at home, you wouldn't even meet her a week to
No.
go out with your friends. Sorry, we can't. We are not.
My lord, I've instructed the SHO is not permitting us to make calls.
That's of a different nature. Then
Only
you can file a
once it
contempt.
was permitted.
Then you can file a contempt. Mr. Kabir, we are not disposing this of. You won't get a good order.
Would your lordship permit me to take this before the trial court? Only condition number 2, if it can
We
be.
don't know the next circuit, but we can give you
Condition number
liberty.
2.
We'll direct to the condition number 2 only will not help you because the other conditions still.
But if your lordship says that throughout the trial is not required, then I can try and convince the sessions, the learned magistrate, CJ. Because this is a magistrate tribunal offence, my lord, at the end of the
Suppose
day.
if we even if we modify that, Mr. Kavit, then 4 and 5 prevents the court from doing it. Because the other conditions cannot be ensured. You have to understand that also.
Then if your lordship may water down 4 and 5 to the extent that I will only to the extent of communication to this family.
Not right.
Well, with my candid submission.
Family, yes, definitely is 2 SHOs as the other division makes us.
Not a very honest submission. This boy is in a terrible condition. He has been here 3 years. He is here after his incarceration also. This is not a short period of time. No end to this trial because 19 witnesses. They've done 2 witnesses in 3 years. 19 witnesses may take any length of time. Not kindly consider that while I'm enjoying my liberty, my life means nothing.
Sir, I really fully understand and appreciate. But the difficulty is, suppose you are held guilty ultimately, you are convicted. Now, then we cannot illegitimize what we are legitimizing now at the stage of bail.
I appreciate that.
Now, if you suppose you are actually guilty of that, suppose the picture you are painting is not correct, you have to balance the things. If that picture is not correct, the day you go out or you have access to your phone on internet, you can contact that lady, that spy or someone else, and you
I
can
appreciate
project that she's a new girlfriend or a friend, a male also.
I appreciate that.
And you will do the same thing. You will be giving information again or doing some other sort of disruptive activities. We hate to say this. We are, as by now you must know that the otherwise the disposition of the bench regarding bail.
My lord,
You must be knowing that. But this is a very serious allegation. Don't take a chance here. You choose your options. Either you could.
No, I will not. That much liberty I will not.
To the dismay and chagrin of Mr. Kormakar, we are giving you that liberty to choose whether you should want to go to the trial court, or trial court won't help you. We are directing you to file an affidavit regarding the composition of your family with the court. The petitioner seeks a modification of conditions of bail. One of the primary premises of such prayer is that the petitioner's mother has suffered a fracture and requires immediate medical treatment, necessitating the petitioner to visit her or at least to establish independent contact with her. In order to decide such question, obviously in the light of the other circumstances, we direct the petitioner, we grant leave to the petitioner to file a supplementary affidavit disclosing the composition of his family in Uttar Pradesh, with an advance copy to the learned public prosecutor. The matter shall next be listed in the next circuit. Next para, we make it abundantly clear that we have not touched upon the merits of the application at all.
So the report. Yes.
Report.
Misconduct.
Confirm
all that.
Thank you. Good sir.
Conduct.
Good sir. In the meantime, on the returnable date, the state shall file a report disclosing the conduct of the petitioner while in incarceration, also with an advance copy to the learned advocate on record for the petition.
Just like all things, if it comments to your lordship, one is that my learned friend can also bring a report as to the status of the trial. Because what is going on in the trial? In the above report, the state shall also disclose the current stage of the trial. And the third thing is, if it comments to your lordship, that I have confidence that this is the document I have been instructed to. Let my learned friend verify. The police here, they contact the police there and verify that the mother is genuinely sick or not. That will assist my cause at least to show that I'm not just making
the public prosecutor has his opportunity, will have his opportunity to contest it. Then he must be producing documents. Regarding the SHO, what about the SHO not giving him access to his phone regularly?
That opportunity was given, that was done one or two times, but after that, it is not. Whether it was state or not, if your lordship can at least say that this order be given effect to. The order at page 22.
We make it, we further clarify that the liberty given to the petitioner vide order dated November 13, 2024 in CRM within bracket DB7 of 2024 within bracket IA number CRAN 1 of 2024 shall be implemented and given full effect to by all concerned.
I'm very good.
Be grateful to her ladyship.
No, I'm grateful to the bench. And I'm grateful to the lordship for hearing.
No, it slipped my mind. It actually has slipped my mind. So we'll be dispersing, and after 15 minutes, I'll be sitting up to 2. Her ladyship will decide how long she'll sit.
क्या हो
Then compounding is made if the magistrate at a subsequent stage, compounding can be allowed subject to condition that accused will be required to pay 10%. Similarly, if the application for compounding is made before the sessions court or a high court in revision or appeal, such compounding may be allowed, but that revision has to be maintainable. Against the conviction order, no confirmation order, no revision lies.
Your Lordship, I will also pay the check amount if for the revision court.
Otherwise, is that you satisfy the court that the revision is maintainable against this confirmation order. Otherwise, any revision is maintainable against that.
Your Lordship, what are the guidelines?
Guidelines are different. For that guidelines to be implemented, the revision has to be maintainable in the first instance.
Your Lordship, the paragraph 40,
40, yes. Yes.
Your Lordship, keeping in view of the aforesaid findings, the appeal is allowed in full order passed by the High Court, Session Court are restored with the direction to respondent number one accused to pay rupees 7 lakh 5,000 rupees is 15 equated monthly installment.
Yes, Mr. Kormakar, and you also, why shouldn't this revision or appeal? So a second appeal does not lie against the confirmation. Revision is the only procedure. So he has filed a revision, then why shouldn't this the para 37 C should not apply? C should apply if he wants to pay 15%. At the first instance,
These are all discretionary and these benefits are extended to a person who had the
138 is
intention-
not a murder. I mean, 138 is for non-payment.
Since 2019.
Supreme Court is consistently holding that in civil disputes, otherwise it's not maintained. But because it's 138,
But again, we will not pay the installments. I'm very much sure about it. This is just a.
That will be a condition of bail.
Just will prolong this, that's all.
that will be a condition of bail. If he jumps bail, then he comes in again, and the diet will change again. He'll have a different food.
Till date, he has been given opportunity.
No, this is the
I have
first
not
opportunity.
gotten it.
This is the first opportunity. He'll get 15% at least. Putting him in jail, putting him in jail, putting him in jail won't get you anything. This will at least get you 15%. He has to pay that amount.
He won't pay anything. He has come empty-handed.
If he does not pay 15%, he doesn't get the bail in the first place.
15%.
That will be a condition.
15% at least.
No, Supreme Court says 15.
That is again on a different footing altogether, not in a situation like this. I mean,
No different footing. Same footing. 138, there cannot be any different footing.
the conduct of that, I mean, the conduct has to be seen.
See, we'll keep the revisional application pending.
But I feel that if he's given a day's time to think about it, And sorry, otherwise he goes.
What does your client do otherwise?
He's an insurance agent.
Sir, I am a depressed person, sir. Someone is taking medicine.
You,
After someone here searched me.
he's a petitioner.
Depression.
Who is he?
Everyday practice.
We are hearing counsel, we don't hear clients when we hear counsel. Please tell him. Please tell him that we won't hear him because you are representing him. Please tell him to take a back seat. Please tell him to go back and sit.
He is suffering from the COVID-19.
No, he is on bail now. The-
Today,
Who is he? The person standing behind you?
today fixed for surrender. Last
Oh.
week.
Today you have to then put in 15%. He's ready. Today itself he has to pay 15% then. Otherwise he has to surrender and get bail.
Sometime maybe.
No, then you don't get. You surrender.
Then
See, we'll permit you to surrender before the court. We'll keep the revisional application alive. When you are prepared to pay that 15%, then we are give you liberty to renew this prayer for bail. Now we are not granting bail. We are not granting bail now. If you want, we can reject or we can keep the bail and the revisional application pending. We'll keep it in the next circuit when you arrange 15%.
it's a today fixed for the all report.
He has to go there and surrender today
Yeah, I will surrender.
and pay 15%. When can you pay that 15%? When you pay 15%, only then you will get bail.
I will try my best. I will try my best.
So putting that condition, if you can pay that amount,
20%, 50%. I will pay today.
that payment has to be made, Mr. Kormakar, as per this to the complainant. Let him pay 15% and get the bail. He'll get some amount, at least he'll see the color of some money. No, but then also, but 15% won't do. Then we have to fix the installments also. You pay 15%, get bill, then never pay anything.
Cost and the check amount will be given to the installment.
What is the installment you are seeking?
Bharat, please 10% because he's very small. We can't be.
Insurance agent poor.
He's suffering from the COVID-19.
COVID-19, we are in 26. If you are suffering from COVID-19, he won't be behind you addressing the court. Sorry, can't. That's not very credible.
Installment.
Then all of us are suffering from COVID-19.
Not but installment, 10 installment may be given.
No question of 10 installments. What is the total amount?
Total is 2 lakhs for the
2
check
lakhs.
amount and the bill fine it is 3 lakhs.
With fine means?
It is 3 lakhs total.
Why with fine? That was imposed.
That was it. 3 lakhs and 6%.
What is the 15%? Please calculate. Use your phone and just calculate and say 15%. What is the amount?
30 lakhs. 30,000. 30,000.
15%. Just check up.
30,000.
30,000.
30,000.
30,000. 10%.
45%.
45,000. Mr. Kormakar is very sound in money matters.
Yes.
That's very
45,000. I shared that trait with you. 45,000 you have to pay.
45,000.
Yes.
To
get the-
you're saying 30% has been given the cost. So all check amount, 30% I have to give as per this that is something.
Yes, 15% of the check amount, right? What will be 15% of 2 lakh?
30,000.
30,000. 30,000.
So let's take amount.
Yes, he's right. The Supreme Court judgment says 30,000 of the 15% of the check amount.
And you're saying that at least installment of 30 installment may be given.
What installments?
13 months.
No.
You know, as per this, there is, as per 40 paragraph, there is a 50 equivalent monthly installment. This is the 50 installment.
No, Mr. Kormokar and you also, what is your surname? Mr. Goldar. Mr. Goldar and Mr. Kormokar, both of you, please come to para 38 of this chapter. That's the revised guidelines actually. Now, C, 38C says similarly, if the payment of check amount is made before the sessions court, that for that he has to pay the check amount. We'll keep this open for him. If he pays the check amount, then this compounding can be considered. But for the time being, it's 30%, 15% of the check amount. So, no, immediately 30,000. 30,000 today.
And the check amount in the 10 installments.
10 installments per month, how much?
You
10 installments, where do you get it? Installments is the Supreme Court judgment. And first installment is given.
first of all, in the 10 equal installment.
What is that?
This is
Show
paragraph 40. Keeping in view the portion findings,
that was done in that particular case.
the appeal is allowed the impugned order passed by the High Court dated April 26, session court are
Installments, the rest of the amount. Supreme Court granted 15. High Court is a lesser court, so let us give him 10. Money, what's the fun in keeping in jail? That. But 30,000 is to be by account to check in the name of the complainant.
10 installments.
First 30,000 today. Again check. Right. Online transfer. Online transfer. Today.
Say.
Here is online transfer.
So you can give your particulars, your client, you have contact with your client. We will take the particulars and give it to your learned friend. To do it. Good. The not yet, not highly, because only 10 installments. The petitioner, the present petitioner application has been filed against an order of confirmation by the appellate court of a conviction of the petitioner primarily under section 138 of the Negotiable Instruments Act. Pushdown. Next para. The total check amount was rupees 2 lakh and the fine imposed was to the tune of further tune of rupees 1 lakh. Pushdown. Next para. Learned counsel appearing for the petitioner cites reported at 2025 SCC Online SC 2069, where the Honorable Supreme Court framed and revisited the guidelines formulated in respect of such offenses, as per the said guidelines, if an application for compounding is made before the Sessions Court or a High Court in revision or appeal, such compounding may be allowed on the condition that the accused pays 15% of the check amount by way of costs. So next para, the guidelines were revised by the Supreme Court and it was observed that if the payment of check amount is made before the Sessions Court or a High Court in revision or appeal, such court may compound the offence on the condition that the accused pays 7.5% of the check amount by way of costs. So next para, learned counsel for the petitioner submits on instruction that the petitioner is agreeable to pay 15% of the check amount to the tune of rupees 30,000 during the course of the day, since the due date of surrender is tomorrow, that is April 27, 2026. To next para, learned counsel for the complainant opposes such prayer and submits that in view of the past conduct of the petitioner, comma, the petitioner ought not be granted the benefit of bail at this stage. Whose next parallel, public prosecutor also opposes the prayer for bail and contends that the petitioner missed opportunities to file applications before the court of the magistrate or the appellate court. Whose next para, however, comma, on a perusal of the guidelines of the Supreme Court, comma, as formulated in paragraph 37 of the above judgment, of the cited judgment, and further tweaked TWEAAED in paragraph 38 thereof, comma, in a revisional application before this court, comma, the petitioner is entitled, comma, if he seeks compounding, comma, to get such relief upon payment of 15% of the check amount by way of costs. Whose next para, in such view of the matter, comma, CRAN 11 of 2026 is allowed. CRAN 11, what is the prayer for bail or compounding? Bail. CRM installed. CRAN is the main challenge. CRM 11 of 2026 and CRAN 1 of 2026. No, you have not filed any revisional application.
It is 1920, 1990.
Revisional
I was 1990.
item
90. 25 of, yeah.
well, it's a board na. This along with 19, comma the 19 code. ওই দুটো অ্যাপ্লিকেশন যেগুলো বললাম CRM such and CRAN such and such are allowed, comma, thereby granting bail to the petitioner on condition that the petitioner pays 15% of the check amount of rupees 2 lakh, comma, that is rupees 30,000 to the complainant by direct online bank transfer during the course of the day, comma, at the bank account of the complainant, comma, the particulars of which shall be furnished immediately by learned counsel for the complainant to his counterpart appearing for the petitioner, which are subject to such online transfer, comma, the petitioner shall remain enlarged on bail, comma, subject, however, to the further condition that the balance due amount shall be paid by 10 equal monthly installments, comma, the first of which shall commence for the month of May 2026, comma, payable by May 31, 2026, and thereafter by the last day of each succeeding month. Which the next para, it is made clear that in the event of default in payment of any of the installments, comma, it will be deemed that the conditions of bail are violated and the petitioner and the bail shall stand cancelled and the petitioner shall be taken into custody. The revisional application, comma, bearing CRR number 25 of 2026 shall be listed before the next circuit for passing further orders.
Remaining amount has not been clarified. Remaining amount of these, remaining fine, including the fine amount or?
Acha. Remaining amount has to include that 1 lakh also.
Yes, ma'am.
Remaining amount will be remaining of 3 lakh out of 3 lakh. So 3 lakh. Yes.
2 lakhs.
No,
Check all the 2 lakhs.
the total imposed fine is also there 1 lakh.
Total amount is check amount is 2 lakhs.
But the installments will include the fine amount as well.
No, but the Supreme Court
Guidelines does not say.
guidelines says payment of check amount, and in this case, 7,50,000 was.
7 lakh is the doctor.
No, let me-
I want to 2 lakh.
No.
I want to 2
One second. No, in that case also the entire amount was included. Because there, the loan was of 56 lakh.
The loan is only 2 lakhs.
In Supreme Court, loan was 6 lakh.
The 6 lakh
Installments were granted in respect of 7,50,000.
check amount in my case is 2 lakhs, not 6 lakhs. 2 lakh is
It is further clarified
check amount.
that the said remaining installments shall be construed in reference to the total amount of rupees 3 lakh, including rupees 2 lakh check amount and rupees 1 lakh fine imposed on the petitioner. The installments will be the remaining amount, the balance amount of entire 3 lakh, not 2 lakh only.
10 installment. 10 installment. There is a my
10 installment. 30,000 you are paying today.
euros.
The remaining balance out of the 3 lakh will be paid by 10 installments.
10 installment.
27,000 per month.
The amount of check amount is not 3 lakhs, 2 lakhs.
Next.
So your check amount is 2 lakhs.
Yes.
Your lordship. Check amount 2 lakhs. So your cost only 30,000. Your lordship. Please, your lordship.
Yes.
Check amount is only 2 lakhs.
Item number 4.
Yes.
request is appointed.
Yes.
I am agreeing.
Yes, Mr. Halder, what is your review?
For the respondent number 3, at the very outset, Your Lordship, I would like to submit that I have a prayer for deletion of respondent number.
See,
Kindly present cost item here.
I am appealing for respondent number 4. I should kindly see the name of respondent number. Practice.
In a review application, Your Lordship, how can a party who is not a party to the original proceeding be included as a party?
Application for liberty.
Leave has been sought
I was
for
not,
only for a third party.
why are the advocates to be, why have you included the advocates? Because of the reason, they have
That before the tribunal. and
they appeal instruction.
No. they have-
Tomorrow your client will file a similar challenge against you saying that you are review application, sorry. This is not a criminal complaint you are lodging or a bar council complaint you are lodging. Review application, only the parties were there in the main application, and I'll impose costs on your client for implementing advocates. 2 advocates. The advocates who appeared for the other side.
Well,
Yes.
Will impose cost on your client, sorry. I'll impose deletion, not only deletion I'll direct immediately and I'll impose cost for including them in the first place. Tomorrow you'll impute a judge also, why not? That judge passed the order, I'm that judge. Let it be adjusted from my salary. No, advocates are teachers of instruction, they act on instruction. No advocate, whoever is the advocate. We are not going by the names of the advocates. Advocates cannot be imputed. Advocates cannot be any advocate, the junior most
There is
advocate.
no prayer and claim against them.
Then all the more I'm deleting it. Before passing any order, Mr. Secretary, please take this. At the outset, an objection is taken on behalf of the respondents as to the implement of respondent numbers 3 and 4, who are learned advocates representing the respondent number 1. One and parties. Respondent numbers 1 and 2 in the original proceeding, from which the review application arises. Push up next para. Upon hearing learned counsel for the parties, it transpires that the petitioner seeks to level allegations against such learned advocates. Push up, however, whatever may be the nature of the allegations, learned advocates are creatures of instruction by their clients and are not necessary or even proper parties in a review application, in a lease between the parties. Push up next para, merely because the said learned advocates represented one of the sides in the original litigation does not entitle the petitioner to implead them as parties in the review application, comma, particularly since there is no scope of any relief being sought against them. Push up such practice is strongly deprecated. Push up the learned advocate on record for the petitioner is directed to delete the name of respondent numbers 3 and 4 from the cause title of the present application during the course of the day. Pushed up, the said respondents are hereby expunged from the review application. Pushed up, in view of having impleaded learned advocates, comma, the petitioner shall pay costs of rupees 10,000 each to each of the deleted respondent numbers 3 and 4 within a week from date. Pushed up, the review application is now taken up for hearing. Yes, what is the matter?
One more thing, madam. If my lord sees paragraphs also, there are allegations. Paragraph number 9 of the, my lord may kindly come to, the application for resolution of the
We will direct affidavits in opposition. Allegations, Mr. Kumar, we cannot preclude them at the outset. We file your opposition and take all your points.
No, my lord has explained that.
They are not required for it.
No, I am appearing for respondent number 4.
Oh,
But since,
which paragraph? Give us the
my
paragraph.
lord may kindly come to paragraph number 9 of the application for continuation of the letter. Page number 7.
The review application is now taken up for hearing. Last line. The review application is now taken up for hearing.
Yeah.
The condonation application is now taken up.
Right.
Which can? One.
My lord, it ought to be can 1, my lord.
Yes, can. Paragraph 9.
Paragraph number 9. Three and 4 are the learned advocates. Paragraph number 13, my lord. And paragraph number 15, my lord.
Let him withdraw the application, let him.
Yes, let him withdraw, my lord.
Even 10, 11, 12, everywhere, your lordship, even 10 and 11.
When I am submitting that, I will not press it, I will file it. Withdraw it. That would be better. Leaving apart the allegations against the learned advocates, I will.
Is now taken up for hearing. Take it. It is further found from the averments made in Can 1 of 2026, that serious and baseless allegations have been made against learned counsel who represented the respondent numbers 1 and 2 in the earlier round of litigation. To sub next para, I do not find any corroboration of such material from the other parts of the pleadings or from any document filed before this court. Push up, such reckless allegations amount to browbeating learned counsel, who represent their clients, which tantamounts to interfering with the process of delivery of justice. Push up, at this juncture, learned counsel for the review applicant seeks to withdraw the matter and file afresh by expunging / deleting all the allegations leveled against the concerned counsel. Push up, accordingly, Can 1 of 20, accordingly, RBW 6 of 2026, along with Can 1 of 2026 and Can 2 of 2026, are dismissed as withdrawn, with liberty to the petitioner, review applicant, to file afresh on the self-same cause of action, by omitting all allegations made against learned counsel who appeared for the parties at any point of time. Mr. No less to cost. Very bad taste, Mr. Halder. You should not have drafted this.
Well, my instructed me.
Your client instructed you and you will do it. I'm not saying that allegations cannot be leveled at advocates. But for appearing for counsel, you are saying that they hatched a plan before the tribunal. There may be serious allegations against advocates, against judges also. Similar footing. You may have a specific allegation, but then you have to substantiate it from somewhere. Reckless allegations, this is interference with process of justice. And you are lucky that a criminal contempt is not initiated. Because what happens, Mr. Haldar, whenever some counsel appears, he or she will be in fear that tomorrow the other side may level allegations against me. Now, this is interference with the process of justice. That's why we say it. Thank you. Next.
Item 5. WPA 153.
Stone crusher.
Yes, yes.
I am being crushed under stone crusher. IPZ you have brought.
It is ICR there. It is there.
ICRZ, right.
Before I take lordships,
ICRZ for
yes, yes,
North, Middle and South
yes.
and Greater Nicobar. I've done my homework also.
No, I have been the homework, then I download, then I. Not the candy come once 41. Why the ICR is required in this instance? Not the pay no 41 is the certificate issued by the Calcutta of the petition.
So this challenge was preferred by Mr. Kumar against Mr. Vinu Kumar against the refusal of the Pollution Control Board to Pollution Control Authority to give you a certificate by insisting that you should get this clearance from which
Forest Authority being a competent authority issued the ICR.
41. Let us come to 41.
Not 41.
Yes.
Why the instant case is particular ICR that has been invoked by the Pollution Control Authority? The reason behind that is lordship.
41 of this. That's
A particular on this.
this. The one.
Yes, yes, that is right. 41. No, actually 41 of the rate petition. I'm sorry, 41 of the rate.
They're not a certificate.
Yes, the second paragraph, as per the record,
Yes.
the subject land is located 165 meters away from the high tide line. However, for the approach part, you will see the high tide line is at distance of 210 meters. Not, it is 210 meters, take it apart at 210 meters. It may not be kindly come to the ICR notification.
Yes.
Not, it has been indicated as option is also gone to it. It says first is that B. Second page not B. Top.
Yes. Yes.
In view of the
Middle North South Greater Nicobar.
Yes,
Yes.
So Lord, I take the ships to the consent provision. Lord Roman 3.
Roman 3. Yes.
The island of Middle Andaman, North Andaman, South Andaman, and Greater Nicobar shall be managed based on ICRZ having the following jurisdiction, namely
Up to 500 meters landward side. Yes.
because it is
This is from the HTL.
that is why it does not affect the authority.
Yes. See that show us the restriction.
Yes. ICRZ 2.
Yes.
The areas that have been developed up to or close to the shoreline. The expression developed areas refer as that were within the existing municipal limits or existing legally designated urban areas, which are substantially built up and has been provided drainage, approach, roads, and other infrastructure.
This is such an area.
Yes. But the next one, not as there why the after the government's intervention, a committee has been constituted to manage the affairs of the issues. Lord may kindly come to. Lord should want to know whether the stone crusher has been mentioned or not. Lord may kindly this.
Even if it's something broad has been mentioned, which covers stone crusher,
Yes.
stone crusher need not be mentioned specifically. That we cannot cover up.
Yes, the guidelines for the management of concern and operations.
Yes.
Lord, I given
Yes, you have given.
guidelines for the management of concern.
Yes, yes, yes.
Clause 5, Lord. Issuance of consent order and operation. The state board of it as may be by issue of consent order up to the period specified. But I take lordships to red category of industries. If it is a red category of industries, 5 years.
5 years for what?
5 years not for operating, consent to operate is for period of particular 5 years. Thereafter they have to again obtain the cost.
After.
Lord, may kindly come to page number 35 of the same guidelines, Lord.
Please certify. Yes.
75, Lord, it is given list of industries.
Yes, yes.
It's a red category.
Yes.
1A and 1B.
Stone crusher 63.
63. Lord, it is come under red category, so 5 years
Yes.
they have to obtain. Lord, the only difficulty is that when the authorities being a forest authority is a public authority has to give a based on the map. They are giving the longitude and latitude. They found that it is come within the parameter of 500.
Yes, Mr. Kumar is challenging the premise of that. They cannot insist upon that. But that, we won't enter into that, your assessment of this.
So that's, it's required, they have to
Yes,
apply,
Mr.
then they have to consider whether if it is, they give an NOC.
Will dispose of the petition with an expectation that they'll do it. No, you have to obtain that.
Yeah, they have to apply it.
You have to apply for
My
that.
lord, this island coastal regulation zone, my lord has seen which my learned friend has relied on.
Yes.
So my lord, can you come to second page, which my learned friend relied clause B. Thereafter, Roman 2, the island of Andaman and Nicobar and Lakshadweep,
Yes.
other than the four mentionings of
IAMPs.
so and so.
IAMPs is the smaller islands and Lakshadweep.
Andaman and Nicobar Island Protection Zone, prepare IIM plan specifying there in the area.
One is ICRZ, which is these three Andaman districts, and Greater Nicobar,
Yes.
basically.
Yeah.
And IIMP covers Lakshadweep and the other smaller islands. Basically, broad. Long Island and some.
And within a period of 1 year from the date of this notification.
You are reading what? 2?
2 mile, one
Two.
1 mile.
2, 1 or 2?
Roman 2.
Roman 2 relates to IAMPs, not
Yes,
regarding this land is on Southern Andaman, South Andaman.
Yes, my lord.
South Andaman is not covered by 2, Roman 2. It's covered by Roman 1. B.
My lord.
Two categories, Mr. Kumar.
Well,
One is IAMPs governing Lakshadweep and the smaller islands, and basically this ICRZ, which covers the others. You are covered by ICRZ, South Andaman.
Yes.
South Andaman. I was wanting this only. 2019 notification has also come out, but that only some areas have been notified.
So the plan has still not been done.
The plan has done, yes. We have also done it home.
Don't you want to know the exact on this issue?
No, we had a program actually. My court officers are laughing because we had a program yesterday, Saturday, on this. So I had to do my homework on this, the entire thing. But I did not look into stone crusher unit, obviously, because it's a subject of litigation, but you are pointing out. Therefore,
So my lord.
we'll refer to this and dispose of the writ petition. We'll give you liberty to apply. You have that liberty.
Already my lord application was.
No, not this application. You'll have to take consent.
My lord.
For that consent,
My lord, can you see 19th February 2025, page 45.
is 45 years.
This is the letter by which they have asked for
Yes,
this clearance. my lord.
yes. ICRZ claim. Correctly so. Correctly so.
But I just seek a base accommodation, my lord. Only I will take inspection, I will come. I will not make any argument. I will just take inspection, my lord.
We'll record what happened today and then.
Yes.
Otherwise, I'll forget.
Yes.
Learned counsel for you are for which respondent? Because you are
My learned friend is appearing for 1 and 2.
1 and 2. Learned counsel for the respondent numbers 1 and 2 cites the IPZ within bracket Island Protection Zone regulation dated January 6, 2011 and submits that as per clause capital B thereof, comma, the South Andaman district, comma, among others, comma, is governed by the regime contemplated under the IPZ notification covered by Island Coastal known as Island Coastal Regulation Zone within bracket ICRZ. Fuster, it is noteworthy to mention that other islands of Lakshadweep, apart from those covered by the ICRZ regime, are covered by IIMPs, that is Integrated Islands Management Plan. First of next para, it is submitted that under the aegis of an expert committee, comma, certain guidelines were formulated for implementation of the ICRZ restrictions, comma, a copy of such guidelines is also handed over in court today and kept on record. Full stop. In terms of the said guidelines, comma, which page you said red zone and all? That was
Page number 3.
yes.
Bottom.
In terms of the said guidelines, comma, certain category of industries have been demarcated as red category, orange category, and green category. First up, in terms of clause 5 within bracket 1, comma, different tenures of consent required for such categories of industries have been contemplated. First up, the red category of industries, comma, mentioned in capital Roman I under clause 5 within bracket 1 are governed by schedule capital Roman 5 of the guidelines. Full stop. The list of industries under red category have been enumerated specifically under schedule capital 5. Full stop. Item number, serial number 63 thereof stipulates that stone crushers also come within the purview of red category, and as such, comma, by necessary implication, comma, by dint of clause 5 within bracket 1, comma, require a consent from the IPZ authorities for being set up. Whose next para, it is thus argued that the insistence of the pollution control authorities for the petitioner to obtain such clearance was justified. Whose next para, at this juncture, comma, learned counsel for the petitioner seeks a day apostrophe's accommodation to take appropriate instructions on the issue. Full stop. Accordingly, on the prayer of the petitioner, the matter is adjourned till tomorrow, when it will be listed under the same heading, top heading as well. Yes. This will come under the top heading. Okay. We. What my favorite? Favorite. What's my favorite?
Item number 6. WPCT 290/26.
You have given a notice to the other side. Verbally won't do, they are not appearing. Ms. Chevrolet is hiding behind Mr. Kavi. Catch hold of him and bring him here. Yes, Ms. Chevrolet, you are hiding behind Mr. Kavi. You could clearly see.
I cannot appear in this case.
Why? Personal allegations against you.
Or litigation was there.
You appeared for her.
Yes, but I appeared before the civil court. I cannot appear.
Then he cannot appear for the other side. We cannot afford just like that. You cannot choose it. We can choose anybody. Please, Lavanya Sundari, you have to give a written notice. Written notice, come back before the next setting. Yes. Why? What is your grievance in this city?
The Honorable LD has passed an order to allot me a shelter during on the particular date, October 6th of 2025. Because I am a single lady having no any assets or something, having no income, and my earlier landlord.
Is there any scheme? Please come this side. Can't see you. Come this side. Under any scheme, where is this? You have annexed the scheme. Show us the LG's order.
Endorsement has been provided from the department, which is in page number 11 from the Chief Secretary office, because the Honorable LG has given the direction, passed an order to the direction to the Chief Secretary, and it was passed through directed to the DC on the DC of Southern Oman, and I was called by him and it was, the order was sent to the releaser also. But then finally, the releaser is giving me several false reasons, and they say I will not get because I am not a tsunami victim.
Tsunami victim shelter?
Yes, they told me because the Honorable LG has passed an order only to provide me a government shelter.
You have
He
implemented,
not mention.
ma'am, you have implemented only the LG as a respondent.
Yes, I sent him a mail, several mails to him.
So what sort of direction are you expecting on the LG?
Apply the order.
LG has asked someone else to comply with his order.
He passed an order and I did not get in contact because he is not, the LG is not meeting any public people. I was in contact with the senior PS madam, Srimati Sailaja of the LG, Honorable LG.
Page 11, please come to page 11.
Yes.
Page 11, Assistant Secretary says that complaint about house damage and retention negligence is forwarded to Assistant Director, Administration Office of DC such and such. So therefore, the Assistant Director is to examine your case.
I met him. Then he directed the DC South Andaman to comply to the matter. Then I was called by him. I met him, the former DC, Mr. Arjun Sharma, who left.
What was ultimately? What did he say ultimately?
He said I was allowed because during 2023 also, LG has directed the DC to provide me a shelter and accommodation, government shelter.
Who will provide you that shelter? Who will provide you?
The Revenue Department.
So then you have to make them parties, ma'am. Make them parties.
But nobody has been called by law during 2000.
You have to make them parties. If you have to pass a direction, LG has given an endorsement. LG is not the authority who will give you the shelter. So you have to impede the necessary parties. You have to make them parties. I am granting you leave to impede the other parties also. You file a 1-page, 2-page affidavit by making a prayer that I want to impede these persons as parties to the writ petition. And then it has to go to the next circuit then. There is no time for us. Came at the fag end of that.
So, but I also filed the same, but
What happened? It was allowed or dismissed?
actually during January in this year, January, in the circuit of January, I filed the same and made a party of both to the.
If it was already dismissed, then how can it?
Dismissed. It was passed in shifted to the National Law Adalat, and there one direction has been given and a award has been given that.
Show us that award. You should have annexed that to this. They should have done.
My lord, can I say one thing?
Yes.
That time during January, I was homeless. My landlord has completely demolished the house, and I was made homeless. Completely. I was been at the shelter with my pet dogs at the Aberdeen Thana police station vehicle shed for 10 long days. I was simply abused, harassed, no home, being made homeless completely. And at the night also, before.
Compliance report was to be submitted to the secretary. The administration was already directed. You make the whoever is in the administration who is in charge of these matters, make them parties so that the court can pass directions. LG won't do whichever secretary is in charge of the particular department. Would you like legal assistance on that from the Legal Services Authority? Should we direct legal assistance to be given to you?
That is not okay. They are making allegations against me that I am abusing him.
You are abusing the council.
It doesn't make sense because it doesn't make any sense, my lord, because I am having friendly relations with.
No, we understand.
Some
Either you can approach those friendly advocates and ask for advice who you are to implead, or you can do it yourself. Then again, that mistake may occur. So, who are necessary to be impeded? Any advocate will advise you. You approach any advocate who is friendly with you, or you can take the Legal Services Authority help. Whichever, if you want Legal Services Authority help, I can put it in my order right now. Or if you don't want that, you can approach the advocate. You can ask Mr. Sivabalan also, he will help you.
Before you, my lord.
The in view of the relief, in view of the nature of relief sought in the present writ petition, comma, for a direction on the Andaman and Nicobar administration to provide a homeless shelter to the writ petitioner, comma, it is necessary that the appropriate functionaries of the Andaman and Nicobar administration are to be included as parties to the writ petition. Full stop. Accordingly, leave is granted to the writ petition to file an application seeking improvement of such authorities. Full stop. Liberty to the petitioner to mention the writ petition along with the said application, comma, as and when filed. Keep this award with you for the time. Should I put in something regarding legal aid being given to you?
If they are ready, otherwise I will.
If I direct, they will be ready. They have to be ready. Should I direct the legal services authority to provide help to you?
Sorry to say, my lord, no. Because.
I'm not putting it in my order.
Mm,
Wait. Whenever you file that application, with that application, you can mention this writ petition before whichever circuit is available. You have given me that liberty. Next. Thanks.
Number 7, CRF 6 of 125.
Is reversal of rules. Oh, that's that one.
Lordship has restored it.
Again, you will argue in person again.
Because at that time he was arguing from the beginning, but the court has given clear.
The Sunit Kauratkar is appearing in matters. Here, represent me should play for next application. Report from the chamber will be yet to arrive.
What do you say?
স্যার আমি স্যার শুরু থেকে আসছি স্যার এই চ্যাম্বেল থেকে আমি আসছি স্যার এখানে
আপনার এখানে কিসের এগেইনস্টে এসেছেন আপনি কিসের বিরুদ্ধে এসেছেন
পুলিশের বিরুদ্ধে স্যার
হ্যাঁ পুলিশের বিরুদ্ধে বুঝতে পারছি কি আপনার
স্যার আমাকে
অ্যালিগেশন
কোভিড-19 এর সময় স্যার ঘরের থেকে মিথ্যে কথা বলে স্যার 2021 সালের 24 তারিখ আমাকে মিথ্যে কথা বলে স্যার ঘরে নিয়ে মানে থানায় নিয়ে যায় স্যার আমাকে 3 অফিসার মিলে আর আদার্স 8 मतलब 8 মানে ডিউটিতে ছিল স্যার সবাই মিলে আমাকে মেরেছে পুরো মেরে স্যার আমি বাংলাদেশি কি হিন্দু কি মুসলিম স্যার আমাকে পুরো কাপড়া টাপড়া খুলে স্যার থানার মধ্যে পুরো ফুটবলের মতো ফেলে
এই এক মিনিট ভিডিও লাইভ স্ট্রিমিং অফ করে সেই ম্যাটারটার জন্য পাস ওভার দিয়েছি মিস্টার কুমার আপনাকে সাফিসিয়েন্টলি হেল্প করছেন আপনি আমাকে করতে পারেন পাস ওভার whenever Mr. Karmakar comes we'll take up the matter yes
Item number 8.
yes
This is a matter where the petitioner was born an Indian to Indian parents, but for reasons best known to himself, he decided to go abroad to study. When he goes abroad to study, he renounces his Indian citizenship and takes up Canadian citizenship. Now in 2019, he returns back to India. Now he is a Canadian citizen, so he needs a document to be in India. So he takes a X1 visa, which is a visa for persons of Indian origin. That X1 visa allows him to come here. But after coming here, he needs a long-term visa. So he applies for OCI, Overseas Citizen of India. Now he gets that OCI status and is living in India. He's married an Indian girl who is due to deliver their first child a week from now in Calcutta. Now, with his OCI status, he's staying in Andaman because this is his home. He's grown up here, he studied here, his parents. Now, in 2020, he visits Nicobar. Now, in order to visit Nicobar, there are two legal fictions here. The first is you have something called the Foreigners Restricted Order. My lord will kindly see, I'll just show you also the documents one by one, then things will just come together. Kindly come to page 107.
yes
107 is the original Foreigners Restricted Areas Order 1963. Kindly come to page 108, Schedule 1. 108, Schedule 1. On the next page, 109, serial number 7. The Union Territory of Andaman and Nicobar Islands. So from 1963, if a foreigner came into the islands, this applied to you. It was a restricted area. You had to get what was called an RAP, Restricted Area Permit. Now, in connection with the litigation that was pending in India, in this court, page 114, onwards, there are several documents, but I would beseech your lordship to first see page 110. In 2018, there was a litigation in this court. The Ministry of Home Affairs took a decision to denotify certain islands. So that denotification, the list of islands, is at page 113. Page 113, your lordship will find that serial number 32 and 33, Kachal and Nankauri. Page 113.
I find up 29 Kachal and now yes
I'm sorry, 22 and 23.
yes
Kachal and Nankauri.
yes
Now this was till 2022. This has now continued. Kindly see page 115. This is an answer in the Rajya Sabha by the government. Kindly see serial number B2, the last paragraph. As a result, the Ministry of Home Affairs has relaxed the restricted area permit for a further period of 5 years till 2027 for the identified islands.
no
Page-
this is the page
My lord, this is at page 115.
yes
The answer in the Rajya Sabha, the last paragraph there. For a better and smooth travel experience of tourist Union Territory, Ministry of Tourism regularly coordinates with Ministry of Home Affairs. As a result,
relax
NHS relaxed. This was in the Rajya Sabha.
yes
Page 117 is in the Lok Sabha. The last two lines on the page, your lordship will find again 30 islands in the Union Territory of Andaman and Nicobar Islands, including North Sentinel, were excluded from the restricted area permit regime till 31/12/22, subject to certain conditions. So this was later extended to 27. Thereafter, the slightly clearer copy of those 30 is at page 122, my lord. And what is most important is the mentioning there.
page 122. The document in question starts at page 119 and 122 is the list. Again, at 22 and 23, might not look at Kachar and Nankoti. And the paragraph after that, accordingly, foreigners will not require restricted area permit for visiting the above mentioned islands. Now, this is the first legal fiction.
This 122 is a replica of that 113.
Of the same. Now, there's a second legal fiction here. So, this is a restricted area part of the islands. The second thing is with
You went to Lankauri.
I went to Nankori. Now, the second part of it is the tribal areas. So, restricted areas is one concept, tribal area is another concept. For that, find out kindly comes to page 130.
Yes.
Now, in the British times, there were rules which post-independence gave rise to this regulation in 1956. It's called the PAT regulation, Andaman and Nicobar Protection of Aboriginal Tribes Regulation. The original PAT regulation had a tourist pass that was required, which your lordship will get at page 132. The Chief Commissioner may, by application, prohibit any person other than a member of the Aboriginal tribes or any class of persons other than members of the Aboriginal tribes from entering a reserved area except on the authority and subject to the observance of conditions and restrictions of a pass granted by the Deputy Commissioner or by such other officer as the Deputy Commissioner may authorize in writing in this behalf. So under Regulation 7, you have a tribal pass. Now this is amended at page 134 in 2006. In the amendment in 2006, nothing to do with the pass. Thereafter, amended in 2012 at page 136. Again, nothing to do with the pass. So the original 1956 Regulation 7 remains that I require a tribal pass issued by the Deputy Commissioner. So this is a second legal fiction. Restricted area, tribal area. Now I don't need a restricted area permit, but I do need a tribal pass. Now my lord will kindly come to page 139 and my lord will kindly have the Aadhaar Act for a moment. My lord will kindly have a look at the Aadhaar Act and correlate that with page 139. Now I was an Indian. I have an islander identity card because I'm an islander, permanent resident of the islands. I have an Aadhaar card because I was an Indian. Now my lord will kindly see.
But you still require a pass.
I need a pass.
Absolutely. You want to go to the tribal area.
I got a pass, but for the pass, the website requires you to upload your Aadhaar card. Now, first of all, kindly see the Aadhaar Act.
Yes.
Section 2A.
Mr. Kavi, give me half a second. Mr. Kumar, is your client in the passed over matter still there? You call him once, just give me half a minute. Just tell him if he has difficulty, then at least taken up tomorrow because I was to rise at 2, so this will be the last matter I will be taking. And he also, tomorrow also it will appear at the top. Two A.
Aadhaar number means an identification number issued to an individual. Thereafter, kindly see 2B, B for victory, resident. Resident means an individual who has resided in India for a period or periods amounting in all to 182 days or more in the 12 months immediately preceding the date of application for enrollment. Thereafter, 3(1) is the right. Every resident shall be entitled to obtain an Aadhaar number by submitting his demographic and biometric information by undergoing the process, etc., provided that the central government may from time to time notify such other category of individuals who may be entitled. This notification is not. So I'm a resident. I was an Indian. I had a car. Now come to page 139. This is from the Aadhaar UI DAI, Unique Identification Authority of India website. These are their guidelines. Page 139, number 1. I am an Indian having an Aadhaar card now residing outside India and have obtained foreign citizenship. Do I need to convert my Aadhaar as a resident foreign national? And what is the process for the same? No change is required as of now. You may keep using the Aadhaar and any further information in this regard by UADI through website or any other modes. So I show my Aadhaar card and my Islander card, and I get the tribal
This
pass.
is the FAQ.
This is the epic, the guidelines on the website. Because no notification has ever come, and I fall within the definition of resident. Even if I am no longer an Indian, I'm a resident. So I'm entitled to have an Aadhaar, no doubt about it. Now the mistake is this: the website needs you to upload Aadhaar, because nowadays Aadhaar is the basic standard.
Website requires you to upload an Aadhaar for the purpose of this
Tribal pass. So I uploaded it, I get the tribal pass, I go in 2020. Now I go in 2020, I come back, there's no difficulty. Now what happens is, kindly see the show cause that I'm getting at page 144.
Yes, page 144.
144, kindly see the date of the show cause, 20th October 2024. Sir, madam, it has come to our notice that one Ibrahim Nasir Jadwin, Canadian national passport so-and-so, OCI card so-and-so, has obtained a tribal pass based on his previous Indian nationality to visit Uncovery group of islands in the year 2020 by hiding his foreign nationality. Further, he has visited Munaf village, which is one of the islands in the Uncovery group of islands, but has never applied for special permission to visit restricted or prohibited areas in Andaman and Nicobar Islands from the concerned authorities. In this regard, a show cause notice attached along this letter may please be issued, etc. Now, what is the specific terms of the show cause? Page 145, last paragraph. And whereas OCI card holders are entitled to visit any place which falls within the protected or restricted or prohibited areas as notified via MHA notification dated 4/3/21 by the central government, provided that for visiting such places, the OCI card holder shall be required to obtain a special permission or a special permit in terms of the provisions of para 1(4) of the said notification from the competent authority of FRRO or the Indian Mission, but Ibrahim Nasir Jadwin did not obtain prior
This is the
permission.
PAT notification.
No, this is the show cause.
No, the reference is to the.
No, so that I'm coming to that. Now this is the next legal fiction. Under the Citizenship Act, you had what was called PIOs, Person of Indian Origin. Then that was combined with Overseas Citizen of India. I have annexed all the notifications. My note will kindly come first of all to page 107.
Sir, this will take some time. This
My-
second class is very
It
difficult.
may take time. I'm just indicating the prima facie case to get that protection from the court. Thereafter, they have to file their affidavits because I challenge the virus of a notification.
The show cause has been issued as yet.
Show cause was issued in 2024. The show cause was on certain grounds. I answered those grounds. Everything was quiet. Now they have started a case, a police case, an FIR against me on different grounds, which were not there in the show cause. Now there is an amendment brought in the Citizenship Act, which says the OCI can be cancelled for violation of laws which the central government by notification may prescribe. The central government issues a notification saying if you are charge sheeted for an offence where the punishment is more than 7 years, it can be cancelled. That is the notification I've challenged. Because the notification, the parent notification, which allows a certain legislation, subordinate legislation, has been violated, number one. Now they say, we heard you on ground A, show cause was on ground A, but now on ground B, that this FIR is there and a charge sheet has come, without hearing, we are cancelling your OCI card.
But that now charge sheet is the new allegation is independent from this show cause.
Yes.
So they can do that. Why
No.
can't they?
Because
Because it's not connected to this show cause.
No, because the Citizenship Amendment Act says that if you are to cancel it, my lord, kindly see section 7.
Section 7 of the main act.
Of the main act.
Yes.
The first allegation itself, my lord, it can be cancelled. I shall not satisfy your lordship, my lord. I shall satisfy your
Kindly
lordship.
see
Our
7.
first- My lord, on the first allegation itself, Lord, taking the pass, the tribal pass, he has given. Lord, kindly see the application. Lord, my officer is there. What he has written.
Let us hear him second first, then we'll come back to you, Mr.
My
Modi.
lord.
I'll come back to you. Let us hear him first. Yes.
7 capital D.
Yes.
Underneath that subclause small d
Yes.
A. The overseas citizen of India cardholder has violated any of the provisions of this act or provisions of any other law for time being in force, as may be specified by the central government in the notification published in the official gazette.
So official gazette says 7 years, more than 7 years.
Now that notification is what I'm challenging the virus of. Can you see page 203? That is the notification.
Yes.
This is 4th March 2021. In exercise of the powers conferred by so and so. No, I'm sorry. Page 203.
Yes.
In exercise of the powers conferred by clause D of section 7B of the Citizenship Act, the central government hereby states that an overseas citizen from India OCA registration shall be liable to get cancelled when a person has been sentenced to imprisonment for a term of not less than 2 years or has been charge sheeted for an offence entailing punishment of imprisonment for 7 years or more. This does not list a statute. Kindly see the power under 7DA. And then kindly see the proviso to 7 capital B. 7DA says has violated any of the provisions of this act or provisions of any other law for time being in force as may be specified. No law is being specified. They are creating a whole new law. If you had said I'm violating NDPS, I'm violating this, I could have understood. You are creating a new thing which was not there in the original statute. In the original statute, 7D, small d deals with that. And now can we see the proviso to 7 capital D, provided that no order under this section shall be passed unless the overseas citizen of India cardholder has been given a reasonable opportunity of being heard.
Where is that?
The proviso to 7 capital D, at the end of 7 capital D.
Yes.
Before it.
Yes.
Now you issued me a show cause saying I violated a notification of 2021 by visiting a place in 2020. I answered that. You kept quiet on that. Now an FIR is registered against me on the self-same issue that I went to Nicobar by showing an Aadhaar card to get a tribal pass. And in that I am charge sheeted now. And on the basis of that charge sheet, you issue this order cancelling it. If the charge sheet is a ground for cancellation by invoking 7DA as the appeal order does, then I have to be issued a show cause on that issue, not on the issue of visiting a restricted area under a different notification. There's a very subtle difference here.
So no show cause has been given on this.
No. Now the show cause is issued in 2024. At that time, even this FIR didn't exist. This FIR was registered in 2025. So let alone charge sheet, the FIR didn't exist. The show cause talked about violating a notification, which again is very relevant. May I just show that to your lordship? Page 201. When one case couldn't be made out, the second was made out without hearing. Page 201. This is a notification dated 4th March 2021. Annexed to P29. Kindly see clause 1(4). Provided that
there was no separate show cause under this proviso.
Grant of multiple entry lifelong visa for visiting India for any purpose, provided that for undertaking the following activities, the OCI cardholder shall be required to obtain a special permission or special permit, as the case may be from the competent authority of the foreigner's regional registration officer of the Indian mission concerned, namely, clause 4, to visit any place which falls within protected, restricted, prohibited area as notified. But you de-notified the non-Korean culture. So when I got a show cause on this ground, I said two things. Number one, from 2018, it's no longer restricted. And number two, this 2021 notification didn't exist when I went in 2020. So that cause of action failed, they didn't go ahead with it. I was show cause under this. But when the impugned order is passed, kindly see where it is being passed. Kindly come to the impugned order.
2020, it was a restricted area.
No. The denotification of the restricted area happened in 2018.
Oh, yes.
So those 30 islands are no longer restricted. So even in 2021, when this notification came, it still wouldn't apply. But now kindly see the impugned order. Page 221. This is dated 16th April 2026. So the first page, the second paragraph, and whereas following has been brought to the notice of the Government of India, Ibrahim Nasir Jadwat obtained a tribal pass based on his previous Indian nationality to visit Nankauri in 2020 by hiding his foreign nationality. He had also applied for a new tribal pass in March 2020 from the Deputy Commissioner South Andaman to visit Nicobar. He was appointed as Executive Secretary, Nicobar Chamber of Commerce and Industries. NCCI is registered under the Society Registration Number. As per bylaws of NCCI, only Indians are allowed to be members of NCCI. He had visited INS Kartik, Kamorka, Nankauri Island, which is a forward operating base of the Indian Navy, in his official capacity of NCCI, and Munaf village, which is one of the islands in the Nankauri group. Mr. Ibrahim Nasir Jadwat did not obtain special permission required for foreign nationals to visit restricted military defense areas, even though he visited them. Whereas, after consideration of the facts and circumstances, the Government of India, through the FRRO, served a show cause notice dated 20th October 2024, giving him a reasonable opportunity of being heard. Thereafter, page 222, my representation runs into 7 pages with the legal issues. They have just reproduced 3 grounds without considering any of the points I've taken. Now, thereafter, their findings are at page 222, the second part of the page. Number 1, despite relaxation of RAP regime in 2018 for 29 places in the islands, including Nankauri, visited in November 2020, visiting these islands are still subject to clearance prior permission from UT administration, that is Deputy Commissioner South Andaman District, empowered under the PAT regulation not to issue tribal pass to any foreigner except on the grounds, etc. There is no such provision in the law. From 1956, it hasn't been amended. They are reading something into the law which is not there. Thereafter, 2, in spite of acquiring Canadian citizenship in November 2019,
No, you did not have a tribal pass at the relevant point of
I had a tribal pass. That's their whole case.
you say they had a.
Their whole case is how could you get a tribal pass showing your Aadhaar card, passing yourself up as an Indian? But my case is I'm entitled to hold an Aadhaar card. Now the very simple situation is this. Thereafter, there are 3 more grounds, but the power being exercised at page 223 is most vital. The last ground at page 223. Written complaint of ADM South Andaman District, FIR number so and so, was registered at PS Crime and Economic Offences against the subject. Now, therefore, an exercise of power conferred under 70 DA cancels the registration. Now, kindly visualize the situation why it is so urgent. This person is now a Canadian. He has a Canadian passport. In order to remain on Indian soil, he needs an Indian document. Now, the visas by which he came to Canada have expired a long time ago. That's why he had the OCI card. Now you cancel it abruptly. Today he's an illegal alien. You can deport him this minute. You can even arrest him under Foreigners Act and prosecute him for being in India without documents. And now kindly visualize the second situation. It says I am directed to go to Chennai immediately and within 15 days submit the OCI card, it will be cancelled. I can't leave these islands because your lordship knows Andamans is unique in the sense that a foreigner leaving here has to pass through immigration. I have an Aadhaar card and an Islander card which I'm allowed to under law, but I also have a Canadian passport. The minute I try to cross immigration, I will be arrested here. You cannot keep a man in a situation where he has no remedy. I have 2 very simple prayers at this stage. I have made 2 alternate prayers. One is this cancellation order has been passed without hearing me, and the virus of that notification declaring 7 years imprisonment charge sheeting is something which has to be tested because this ultravirus is parent statute. So then this cancellation has to be stayed, giving me the protection for the meantime. Otherwise, this becomes instructions.
No, how is that relevant, that notification for you? What crime?
Because that's what they're invoking. At page 223, they are invoking 7DDA. What law have I violated, my lord? If they say that you're violating.
What is the law they're saying that you're
They're
violating?
not saying. That's our point.
That notification is not germane at all for.
No, my lord, it is germane because that notification is talking about a criminal case being started against me where I'm being charged.
Yes.
So this proceeding now, the grounds of their cancellation are what? A, that I've gone to a restricted area which is not a restricted area. B, that I've passed myself up as an Indian to get a tribal pass by using an Aadhaar, which I'm entitled. C, that there is an FIR started against me and that criminal case is pending against
me. FIR on what?
On the same thing. The FIR that is started is how could you, and I'll show you also something absurd.
What is the punishment for that? 2 years.
No.
Within that.
No, 7. But here, kindly see the ground on which the charge sheet is submitted. This is a certified copy in the middle of the paper. That I went with the Aadhaar card, and the last 3 sentences, kindly see, they're so absurd of that paragraph. That I have retained Indian documents like the Islander card and the Aadhaar card, which I am not permitted to do under law. I mean, the law allows me to do it. As a resident, you don't. Aadhaar is not a proof of citizenship. The Supreme Court is repeatedly saying this. It is a document of residence.
So they say you falsely declared your nationality to be India.
Yes, because in that form, I have uploaded the Aadhaar.
No.
Now there, the minute you upload the Aadhaar, this form basically, to be very candid, is probably not designed for foreigners.
But kindly see the form. My officer is there. He can produce the form before your lordship's court.
The whole point here is this part with regard to the trial. This I will face separately. In fact, it's a summons proceedings. I have been issued summons.
14A Foreigners Act. What does it say?
Visiting restricted areas. That's a punishable offence.
Now the problem is it's not restricted. It is a patch violation, but it's not a 14A violation. That's why they've said.
Foreigner sector আছে? No.
Yes.
In fact, now the Foreigners Act has been repealed.
No.
Now the Foreigners Act actually has been repealed and replaced with the new 2025 law, which is a different discussion altogether. But at that point of time,
When the offence was committed,
yes, but now the arguable proposition is this: that applies to a restricted area, which this is not.
So you rely heavily on the denotification.
My lord, I am relying heavily on various aspects of law, which is something which has to be tested by this court. But in a knee-jerk reaction to throw me out of this country, and I have shown your lordship where my urgency lies, because I have annexed this as a very specific ground. Kindly come to page 228. If I did this in 2020, you had no urgency to act against me for 6 years. Now suddenly in this extreme urgency, page 228, kindly see, this is my wife. In the top table on the right hand side, NMP EDD, that is the estimated date of delivery, 22nd of May. My wife is in Calcutta. I can't even travel to Calcutta now because I have to pass immigration. Now there are 3 conceivable situations. One is the government of India packs me up and sends me back to Canada because there's no other place in this country where I'm safe, in this world where I'm safe. The second situation is this order has to be stayed to the effect that it is not given effect until this writ is disposed of. The third alternative is I may conceivably obtain a long-term visa. You want to cancel my OCI? That's fine. That part will be dealt with by the court. But in the meantime, I have to stay in India. For that, I have to get a long-term visa. Let the Minister of Home Affairs issue that to me. My status in India is what is the issue here. Because this is not a criminal who's come, a foreigner who's come and violated the Indian laws. This is a unique case where he's an Indian who became a foreigner, but is an overseas citizen of India, who is at par with an Indian national in most things. Now, this sort of cancellation.
There's also an allegation that you visited restricted military defense area.
Now, that is another very interesting thing. There are 2 allegations here which are absurd. One of them is that I am a member of the Nicobar Chamber of Commerce and Industry. My lord, I have made statements in my petition and I have annexed documents. My family has been in this island, in these islands since 1900. My grandparents lived at Nicobar. I used to visit there regularly as a boy growing up. Now, at this point of time, Nicobar Chamber of Commerce, because of my
Family is in Namkoria.
lived there, was there. My grandparents were there. I've annexed the documents. Now, now in this situation, I have been going there since I was a boy. Now, the difference is I'm a Canadian national and the Aadhaar has been used. Now, the issue here is very simple. Nicobar Chamber of Commerce asked me to be its honorary secretary. Their allegation is
Aadhaar has not been cancelled.
the Aadhaar cannot be cancelled, Madam.
Has not been cancelled.
Cannot. There's no ground to cancel.
Anything can be cancelled. This has been OCI has been cancelled.
Because there's a statutory
Not you
provision.
don't say cannot.
No, man, with the greatest of respect,
Whether it has
not,
has or has
has
not. That's the question.
No.
Anything can be done.
No, because in the Aadhaar Act, there's no provision for withdrawing it on these sort of situations. In fact, the specific thing is that a foreigner can hold an Aadhaar if he's a resident in that defined term. Anyway, now the
That is one
Nicobar
of the
Chamber of
allegations.
Commerce
Yes.
makes
So that is the
me-
next thing which is coming because you have the allegation is that you obtain an Aadhaar, although you are not an Indian resident, Indian citizen, and obtain this.
Now, the Aadhaar was obtained by me when I was an Indian citizen. And I did not make any changes because the website says I don't need to.
So basically, let us formulate the ground because we
Fine.
cannot go on. Now, one is that you say this notification you are challenging.
My
So even if first ground is 2024 show cause notice was on a different aspect of the matter, and that related to probably that restricted area visit.
restricted area,
And
as well
the
as
answer
Nicobar Chamber of Commerce. Why was I their secretary when I'm an Indian can't be a member of a registered society, according to them. A foreigner cannot be a member of the registered society.
So 2024, your answer is there regarding the restrictive area. You say that
It's not
2018
Right.
denotification is there.
Right.
What about the Chamber of Commerce thing?
The Chamber of Commerce is a private society.
Alright.
I was never a member. I was the executive secretary, the honorary secretary, holding an honorary.
That
post
by
of
itself
family
may not be
relations.
an offense. By itself
not
may
an
not be
offense,
an offense. And you held a tribal pass.
Yes, and the third allegation that they're talking about is SIDM. This was not in the show cause at all. In the impugned order, they are saying that the Society of Indian Defence Manufacturers had held some sort of an expo, and I had attended that. The impugned order refers to that at page 222. It doesn't talk about me visiting naval bases because I didn't go to any naval base. 222, number 4. Society of Indian Defence Manufacturer conducted ANTEC 24, a seminar and exhibition on defence on February 2nd and 3rd, 2024.
So you were invited there as a delegate.
And I went there. They say because it's a defence exposition and you're a foreigner, you are trying to steal defence secrets. Participation is subject to approval from competent authorities. I don't understand. If it's a private conference, seminar, which I'm invited to attend. Now, this is a worst kind of censorship of a foreign nation. Now, this was not in the charge, in the show cause. In the show cause, they're saying I visited a Navy base, which I did not. And my reply is a very detailed reply at page 147. I want to get all the grounds and law. Nothing has been discussed. And that reply was given in November 24. They're cancelling this in March 26, April 26.
Let us hear Mr. Mujib.
My,
Yes, Mr.
my only thing would be,
Yes.
just look at the interim orders I've prayed for. I've asked for the court to mold the relief in such a way that A, I am simply protected with regard to my status. The rest of it can be heard out in due course. Because this matter needs hearing and affidavits.
Yes, Mr. Mujib.
But no doubt he was a Indian national. He surrendered his Indian passport on 17th of October 2019. Got it? Then
Yes.
from 2013 to 2019, he was in Canada for his higher studies.
Right.
And then he has taken the Canadian citizenship on, your lordship, it's October 11, 2019.
Right.
Now, my lord, he arrived India on 28/10/2019 on X1 visa. Your lordship knows, my lord, what is the X1 visa? X1 visa is a long-term visa for stay in India for a foreigner.
X1.
X1. X1. It's a long-term visa. This is just the one step up of about the OCI card. Once you get X1 visa, then you can apply for OCI card.
Very well. Yes.
Malad got it. But he arrived India on the basis of X1 visa on 17/11 on 28/10/2019.
Yes.
Malad got it. And he got
Got
his
it. Got it.
an OCI card issued on 17/11/2020. Now your lordship knows, your lordship has seen the notification where the foreigners, they can go into the restricted area, no doubt about it. But the prior permission is required from the Deputy Commissioner of the Nicobar Island.
He says he had a tribal pass.
No, I'm telling you, lordship, I'm coming. For tribal pass, the one online form has to be filled up. One online form has to be filled up to get the tribal pass. But now kindly see the the online form which he has filled. My officer is there, he will hand over it to your lordships. Kindly see it.
No. No, you can open it up. What's the hide and seek about it?
No, nothing. Not at all.
No,
Kindly see,
Mr. Kumar is having his own fun. He's wanting the court to try to open the sellotape, which the court is aware of these tactics. Yes. You open it. If necessary, show it to Mr. Kabir and then give it.
No.
Your application. Your application.
This is his application. He can always go through it, my lord. I have no problem. But kindly see what he has done.
What is the relevant page? Please open it for me.
All 3 pages are relevant. You just, Mr. Counsel, you please hand over
the relevant pages and then hand over.
the application form. The application form, you please hand over.
Yes.
Application form for tribal pass.
Find out the relevant portion, Mr. Kumar. Mr. Sivabalan can help you. Don't think that you will bask in the sunshine of.
For the timing, I want the application form. That's it, my lord.
Application form, right?
Yes. My lord, kindly see it, my lord. Your lord, you will find first 1, 2, 3, just my lord, the middle of the page is nationality. He himself has disclosed Indian.
Indian, yes.
My lord, got it.
Can I keep this on record? Keep this on record.
Yes, my lord. Then the next page, my lord. Next page.
Yes.
Your lordship will file the application's religion. My lord, got it. Applicant's religion, middle portion.
Yes.
Hinduism. Yes. He is a, my lord, admittedly, my lord, he is a, my lord, he is not a Hindu. This is number 2. Number 3, the next page, my lord, kindly see start date.
Yes.
Kindly see permission date and location.
Start date, yes.
Yes. 3/3/2020 and 8-day end date is 25/2020. Then your lordship will find the last 6-year residential detail. My lord, got it?
Same page. Yes, last year, yes.
Last 6 years, your lordship will find 1/1/2014 end date at 31.
All wrong information. These are all wrong information.
All wrong. My lord, he said in this period he was in India. He was never in India. He was in Canada during this period.
Right.
Then, my lord, kindly turn to the next page. Last, my lord, the 2 answer. Whether in possession of a valid passport, if so, same may be enclosed in original. Saying that no. Your lordship has seen the mark in dot.
No,
Here said no. This is the suppression. And the next one. Are you foreign national? If so, visa and permit issued under foreigners? No. This ground itself, we can terminate in terms of 7D of the Citizenship Act, which is very clear. If your lordship see 7D once.
Yes.
(7D) of the Citizenship Act. What are the criteria on which it can be cancelled?
Yes.
A. The registration as an overseas citizen of India cardholder was obtained by means of fraud, false representation, or concealment of any material fact. But I am asking myself, is it not a concealment of material fact?
Sir, Mojumdar, I fully appreciate, but this is subject to the proviso that first has to be given an opportunity of fraud.
Which one,
The
Milord?
show cause proviso to section 7D at the
Yes.
end of section.
Milord, it was given. Here detailed reply was given. That is there, Milord.
But that show cause was in 2024 on a different ground.
No, Milord, I'm telling you, Lordship. Kindly turn to our show cause first. The show cause your Lordship will get 145.
145.
Kindly see 145 second para.
Yes.
It has been brought to the notice of the government of India that so-and-so has obtained a tribal pass based on the previous Indian nationality to visit Narkori group of island in 2020 by hiding his foreign nationality. He has also applied for new tribal pass in 2020 from the Deputy Commissioner of South Island. He was appointed as Executive Secretary of so-and-so, so-and-so, so-and-so. As per the bylaws of NCCI, only Indians are allowed to be member of NCCI. But this is one of the ground. Milord, he was, Milord, became a member of NCCI, Milord, on the basis of his, Milord, the Indian nationality. Now, your Lordship, there is a bylaw of, Milord, the Chamber of Commerce itself. This shows no foreign national can be member of the, Milord.
But the offence is under what act? For which his OCI is being cancelled?
Which, Milord?
What is the offence for which his OCI is cancelled ultimately? Under Citizenship Act, D 70A.
17, Milord, 17A, 17D, 17DA, Milord, all are coming in that.
Why 7A?
7DA, 7DA.
7D, yes, 7DA. 7DA, yes, I can understand.
Yes, and then your Lordship will find the next one.
Yes. Disaffection towards Constitution.
My Lord.
Next one is 70A.
Next one, 17A, 17D. The overseas citizen of Indian cardholder has, within 5 years after registration under Section 107A, has been sentenced to imprisonment for a not less than 2 years. There was a statement also that 7DA.
Small d, that's what we say.
D, yes.
7 capital D, subclause D.
Yes, yes.
DA.
Registration has been sentenced to
Overseas citizen of
He has
India
not been sentenced to
has
imprisonment.
violated any of the provision of the Act or provision of any other law for time being in its force as may be specified by the central government in notification published in the
But you have not specified any law in the notification.
Milord, the 14 Foreigners Act, Milord, itself, Milord, your Lordship, it covers everything. 14 Foreigners Act, Milord, he was charge sheeted, and your Lordship will find in the finding of the charge sheet, Milord, not only on this score he has given false information, but also, Milord, he cannot be a member of that, Milord, the community on the basis of that he is an Indian citizen.
See, Mr. Mujimdar, I'm very clearly putting it to you, being a member of a community on false information or these things are not legal offences. If the committee wants, it can take steps against him.
No,
That is a
Milord, in the Official Secrets Act, it itself is an offence. Milord, I shall request
but that is not a part of either the show cause or anywhere. We don't find it. Or in the order. Official Secrets Act has not been cited even. Either in the show cause or in your order.
But Milord, this is Milord,
cancelling only on the ground of
ground
of basically violation of the Citizenship Act.
Yes.
So Citizenship Act, it requires a show cause to be given to him, and you have given him a show cause, which we find also, and you have also indicated that he had applied for a new tribal pass, basically 70 capital small a, small a.
Yes.
70 small a I can understand, but 70 small d probably no, because and was it a part? It could not have been a part 70 small d, Mr. Mujumdar, could not have been a part of the show cause notice of 2024, because the FIR was lodged in 2025. Right?
Yes.
So 70 small d could not have been a part of your order.
No, that is not. Will not kindly say it is not. It is not a part of.
So you are citing 70 small d. That's what I am saying.
That is my additional matter. That is my additional submission. Will not kindly see the.
So that is your. I can see you in the light of Mohinder Singh Gill on that. So that you cannot take in this, cannot justify. But 70 small a, yes. prima facie, I find that some case has been made out.
Yes.
By 70 small d, I don't find even a prima facie case having been made out because there was no show cause on that.
And your lordship will find, my lord, during that period in 2020, your lordship
Yes.
knows better than me, my lord, that the car INS Cardiff, it's a naval, my lord, the vessel.
But there is no allegation to that effect. That vague allegation he has been visiting military and defense bases.
No, that is, my lord, that is one of the ground. My lord, kindly see that.
No, but that, see, in a show cause, Mr. Mujumdar, you have been doing thousands of cases where you argue, you have said
Yes.
that show cause has to be very specific on the offense.
Yes.
You cannot give a vague allegation. You are a bad person. I give a show cause to you.
No, show cause that is there, my lord, that is there. 145.
Let us see the show cause. Let us see the show cause page 145. That is
145.
section 7D within bracket small da.
Yes.
That is what I find.
No, show cause 145. Kindly turn to page 145 once.
Yes, 145.
The second para. As per bylaws of NCCI, only Indians are allowed to be member of NCCI. I am not that.
Mr. Mujumdar, all these culminate in the now therefore at page 146. If you please come there, page 146.
Yes.
Because there now therefore contains the crux of your allegation against. Page 146. Now therefore the paragraph. All the previous are narratives. Whereas, and now therefore under section 70, this is a charge actually.
Yes.
He, small da of the Citizenship Act, notifies that you have to he is to show cause as to why OCI registration should not be cancelled. So that I can find only this in the show cause, which is at the end of it, because that is the charge actually. The charging section is section 7D small da in the show cause notice. So for that you are citing this false information, this application form.
Application form. This is number one. And Milord,
Yes.
he also visited. Milord, your lordship will find 145 second para. He had visited INS Cardiff, which is a forward operating base of Indian Navy, in his official capacity by NCCI of so-and-so village on the island of the narcotic group of island. Ibrahim Nassim
This
has
is an offence under Official Secrets Act.
no, yes, Official Secrets Act, and the special permission is required.
Now, if it's an offence under the Official Secrets Act, you should have given him show cause saying that he has violated Official Secrets Act. This does not say anywhere. It just cites that he has visited a naval base.
Malad, kindly say this is relating to safety, security, and sovereignty of the country.
That's
Being a
the
foreign
usual
national,
mass.
without taking any permission, you are visited a naval camp. Malad, kindly visualize the situation.
Mr. Mujumdar, if he had a tribal pass, suppose he had obtained that by giving false information, which is a different offence altogether.
Yes.
But he had a pass, he was entitled to go wherever he liked on the islands, unless there was a specific restriction. If there was a specific restriction, the naval persons would not let him go there.
For a foreign national, Milord, I am telling you, Lordship, to get a travel pass, Milord, it is from the the Department of MHA, they need to, Milord, a permission. But once
you don't have any mechanism of verification when he applies.
Yes.
You don't have any mechanism of verification. You did not verify that he is not a Hindu. It's apparent from his name. And not Indian also, a mere check would reveal that. So why did you grant him that pass in the first place?
Milord, he applied as if he's an Indian citizen, Milord. Kindly see.
But I admit, Mr. Mujumdar, no, you should have ascertained. If I apply as an Indian citizen, you should first ascertain that. And this is a sensitive area.
This is online. Milord, this is an online pass. Milord, this is an online pass. This is not a physical pass.
Online pass, the application is online.
Yes.
The pass is issued online, but there isn't any verification process. If I come from, say, Timbuktu and say I am an Indian citizen and you will give me the pass.
Milord, we have verified. That is the reason this show cause was given, Milord.
Then the online form would show he was not a Hindu because you are on that also.
Your Lordship has seen how he has, Milord, the misrepresented Hindu.
So, Hindu or not Hindu, we are not interested in that.
We
but
are not
it's false
interested.
information.
But
Even if it's false information, it does not have any German bearing in the context. I mean, I give a false information, yes, my blood group is O negative and my blood group is O positive. So that's an irrelevant information. Hindu or non-Hindu, that's an irrelevant
other
information.
one, Milord, the other
Indian is very important,
yes.
But you must have verified that. So his traveling to the islands with a then valid pass was not an offense. Therefore, he is going with that pass to wherever he wanted in that island at that point of time before it is cancelled, Mr. Majumdar, is not an offense. His offense is only, and rightly you have pointed out, everything boils down to section 7D DA in your show cause, nothing else. So you cannot haul him up for anything else. This Official Secrets Act and these other violations, so against Constitution of India disaffection, these things come in later, not in the show cause. You have mentioned everything, but the charging section you have mentioned is section 7D DA.
Well,
So
7
I asked the DA only there at page
Yeah,
146.
7
So regarding that, I'll ask Mr. Kavi what is his stand on that. Yes, Mr. Kavi, because we are on prima facie case. I am not deciding the reputation. Don't be afraid, Mr. Majumdar.
no, my lord, that is not bad.
I'll not. I cannot dispose of such a short time. This matter is recorded because yes, you are right. If defense of India is concerned, we have to be more sensitive.
My lord, kindly consider that also. A foreign national is going everywhere.
Yes, false information but on very important points. Apart from that, Hindu as Indian.
No, I've seen that. No, I'll explain in his reply as well. He's talked
Most of the things are wrong. Indian.
Because this form has been filled up casually on online thing.
No.
This is something which may be.
Mr. Kavi, you last 6 years residence details here given.
That part I'm answering immediately. His residence has always been in India. His residence has never shifted. Even in the OCI card, kindly see the OCI card, the residence is in India because he doesn't have a residence abroad. Those 6 years he was studying in Canada.
You are a Canadian citizen.
Why not in 19 I became a citizen? From
Yes.
13 to 19, I was studying there, but my residence is here.
Yes, but you filled up this form after 19. After
No,
getting
that is true. That is true. But
So you
my
say you're
permanent-
Indian and you say
My
that
lord, but the fact remains that my permanent residence has always been in India.
70DA is squarely satisfied.
Now, may I say this? 70DA is not satisfied because 70DA talks about violation of the Citizenship Act or any other act which is specified. I did not violate the Citizenship Act. If anything, I violated the PAT laws. Now, until the central government notifies the PAT laws under 7DA,
No, the OCI citizenship, it's an offense under the this act itself, Citizenship Act. 70,
so my lord, where is the offense
Seven-
under the Citizenship Act?
70A.
No, because an offense under the Citizenship Act has to be one of the offenses mentioned. If the offense is giving false information to the DC for the tribal powers, that's an offense under the PAT law.
No, why do you say that? Let us come to section 70.
Yes.
70 says the central government may by order cancel the registration granted under subsection 1 of section 7 capital A. If it is satisfied that A says the registration as an overseas citizen was obtained by means of fraud, false representation or the concealment of any material, that itself is a ground under the
No,
citizenship
no,
act.
no, no, no. Your Lordship is reading DA.
Yes, that is not
Your
applicable.
Lordship is reading only A.
Only
The registration of OCI was obtained by fraud.
that this is an application for tribal pass.
Tribal pass, not OCI. A is not attractive.
Right.
B, disaffection is absolutely absurd. C doesn't apply. D doesn't apply. DA is the one they're invoking and applying. So DA is violation of provisions of this act, which I haven't violated, or any other law as may be specified. If you haven't specified it,
Yes.
you can't invoke it. If they had said in a notification that under 7DA, we are notifying Official Secrets Act, NDPS Act, PAT regulation, that if you violate those, 7DA starts to operate.
So where is that notification? Which page you just gave me?
203.
ওরা কি বলছে শোনো
203. This is 11th August 2025. In fact, this is long after I went. I can argue that this law didn't exist. I can't be prosecuted and punished with something which didn't exist at the time. This came on 11th August 2025. In exercise of the powers conferred by DA of
Before this, there was no notification.
No, now that's why I've given the entire history of the Citizenship Act, all the amendments. There was nothing on DA. Let me show you also where DA came in. Page 194. Kindly come to page 193 first. I will make it absolutely crystal clear. That's why I've annexed everything. Page 193.
Yes.
P27. This is the amendment which happens on 12th December 2019.
Yes.
Can you turn the page 194 section 4?
Yes, I get it from this statute itself.
No matter. Look at the amendments individually of the statute. The statute is showing all the amendments cumulatively. Kindly see 194 section 4.
Yes.
In section 7D, after clause D, the following clause shall be inserted, namely DA, and the proviso was inserted. This amendment is in 2019. Thereafter, page 199. This is the next amendment in 2021.
No, I just want to know, Mr. Kabir, that I don't want the history of.
No, my point is, this is the only
No,
notification.
I only want to know before 11th August 2025, there was no notification
No.
of the DTA.
All the amendments are there. Which means that in 2020, whatever I violated, the consequences for my act didn't exist. You cannot prosecute me or take steps against me with a punishment that didn't exist when I committed the act.
Mr. Mojumdar, I am granting a stay subject to Mr. Kabir, not, but you cannot leave, but your wife is there.
And only after Calcutta, I will not go.
Who will ensure that?
And I will, whatever security is required, I
No,
will.
but OCI cancellation, if you stay that will be difficult.
Yes. But no
I don't
coercive
care.
action will be taken. Well, no, your lordship can
No
say.
coercive action.
No, what is my status in India, my lord, right now, if my OCI is cancelled?
No, that no coercive. The status in India is taken care of by no
No,
coercive
my lord.
action.
No coercive action means I won't be prosecuted. But I'm still, I don't have a document.
But who will ensure that you would you don't leave India? How can we ensure?
I will, your lordship will ask the Minister of Home Affairs to ensure that if immigration counters, it will immediately
That
put
is
on
very
a India. That much power Mr. Mojumdar has.
My lord, if he go through India, he doesn't need immigration within India.
No, Andaman's airport is such a foreigner cannot leave. Andaman's airport is unique. You have to cross immigration.
For you don't have to go through the immigration in Andaman also.
I'm a Canadian, I have to go through immigration.
He's Canadian. No,
At
for
that
now
time, what do I
to move within the country, do you need that?
No.
No, but if he does
No,
not,
it is not.
But I can't leave the islands.
under which provision?
In order to leave the islands, I need to show a valid travel document. If I have a cancelled travel document, how is it a valid travel document?
OCI card is not.
It's a long-term visa. That is what gives me the right to stay in India. You cancel it, you cut away my legs from under me.
Mr. Mujumdar, he does not have the right to stay in India for a day. So no coercive action, you may not extradite him, prosecute or extradite or what.
But when we are saying we will not take it until unless we file the affidavit in opposition, we are not.
No, but what is my document?
No, but tomorrow, suppose tomorrow he wants to leave Andaman and Nicobar Island and go to his wife who is in advanced stage of conception. I mean, she's conceived. So now, if he wants to go to Calcutta to visit his wife, so how can I do that without the OCI
I don't
card?
think the immigration is required. Well, just give me 1 minute. I shall check it from my officer right now.
Take instruction.
Yes.
You are waiting for it.
Don't need. Well, I have taken instruction. Doesn't need it. Just now, I have called her and.
Then I'll put it in my order that your the submission and record. And I'll make it very clear that he will not have any restriction to travel within India.
Within India,
in and out of the Andaman Islands.
Yes.
Andaman Nicobar Islands.
Yes.
And he will be use a server copy of this order. All authorities will act on that.
Yes.
And clear?
And
no coercive action. Yes, Mr. Mujumdar?
They'll let him.
Yes. Something else you want to?
No. That's not correct.
If necessary, Mr. Mujumdar, we can also ask, I will put it in our order that if Mr. Kabir's client wants to leave the islands, he will intimate some authority, nodal authority, whoever.
FRRO.
So here, the superintendent of police.
So FRRO will act on the server copy of this order, permitting him to leave the islands and to come in.
My lord, may I make one additional submission? There is a prayer I have made.
We will permit, and Millard, we want to use a detailed affidavit on this. Millard, it's a very serious issue. We want to use a very detailed.
I won't. Obviously, we have to invite evidence on this serious issue. Yes.
My lord, can we see prayer G? I made an alternative because I expected.
What is it?
My lord, I have applied for a long-term visa. Let them grant that.
Do you expect them to grant a long-term visa?
One visa is lesser than the OCI card.
We cannot compel them to.
No, my lord, your lordship can compel them to, because if I have to stay in India, there has to be a status.
No, we cannot direct the authorities to issue a long-term visa to you.
My lord, kindly envisage.
That is absolutely executive domain.
Yes.
If they don't issue me a visa and the OCI remains cancelled, then what am I? I am a Canadian without a document to stay in India.
No, we cannot direct them to issue a long-term visa. Definitely no. within the scope of this.
Fine, but then let them consider that in the meantime at least.
I can at best say that this will not prevent the authorities
From issuing me a
from
X1B.
No, no. We went to apply them, my lord. Now it is.
I've already applied, I annexed the documents. But it's not been processed.
No, we are not. I am not directing Mr. Mulinder any authority to grant any long-term visa claim.
Yes.
Definitely, I won't in the scope of this writ petition.
Right.
I'll say that this will not prevent him from applying. He has
Already
already
applied.
not prevent the authorities, the concerned authorities, from considering his application for long-term visa
In accordance with law.
in accordance. There are several facets to the present challenge. First stop. Apart from having challenged the virus of a notification dated August 11, 2025, issued by the Ministry of Home Affairs, Government of India, on the ground that the same does not comply with the powers conferred under Section 7 capital D within bracket small da of the Citizenship Act 1955 within bracket as amended bracket close comma. The petitioner has also assailed an order dated April 16, 2026, passed by the Bureau of Immigration, Ministry of Home Affairs, Government of India, cancelling the OCI card of the writ petitioner, bearing number A3902783, and directing him to surrender the same to the authority in the FRRO, Chennai, within 15 days from the date of receipt of the order. So the next parallel, senior counsel appearing for the writ petitioner raises several issues. First, it is contended that in the show cause notice dated October 28, 2024, on the premise of which the impugned order was passed, it was alleged, inter alia, that the petitioner had despite being a foreign national, had applied for and obtained a tribal pass and had visited restricted areas in the Nankauri Island falling within the Greater Nicobar. For next para, it is contended, by placing reliance on the relevant notifications, including the Andaman and Nicobar Islands within bracket protection of aboriginal tribes bracket closed regulation, 1956, it is submitted that the restricted areas under the said notification, insofar as the Nankori Island and certain other areas are concerned, were subsequently denotified from the zone of restricted areas. At the relevant juncture, that is in 2020, when the petitioner visited the Nankori Island, where his ancestors also resided, it was not a restricted area under the regime of the PACT regulation.
This is foreigners restricted area. The order, foreigners restricted area order 1960.
Under the regime of the foreigners restrictive orders,
restricted area order
1956, 1963. For some next para, it is further argued that the impugned notification, I lost the page. It is further argued that the notification dated August 11, 2025 had not seen the light of day when the show cause notice of October 28, 2024 was issued. Thus, there could not, thus, comma, no allegation could have been leveled against the petitioner for violation of clause 7 capital D within bracket small da of the Citizenship Act on the premise of such notification. Pushap, learned senior counsel takes the court through the provisions of section 7 capital D within bracket small da of the Citizenship Act, 1955, which stipulates that the overseas citizen of India cardholders, so CAPC, within bracket OCI cardholder, bracket close, started with when, that when such and such has violated any of the provisions of the said act or provisions of any other law for the time being in force, as may be specified by the central government in the notification published in the official gazette, comma, the rigors of the said provision is attracted. However, comma, the said clause is circumscribed by the proviso to section 7 hyphen capital D, which stipulates that no order under the said section shall be passed unless the OCI cardholder has been given a reasonable opportunity of being heard. Next para, thus, comma, it is argued that if the notification was only published on August 11, 2025, under the contemplation of clause small da of section 7 capital D, comma, on October 28, 2024, comma, when the show cause notice was issued, comma, the petitioner could not have been guilty of the violation of the said provision. Next para, on a more fundamental premise, comma, learned senior counsel points out that section 7 capital D within that the proviso to section 7 capital D stipulates submits that section 7 within bracket 7 hyphen capital D within bracket small da of the 1955 Act stipulates that only violations of any of the provisions of the said act within bracket which is not applicable in the present case, bracket close, or of any other law, double inverted, for time being in force as may be specified by the central government in the notification published in the official gazette, double inverted close, comma, can a person be hauled up under the said provision. Thus, comma, it is contended that the limited power of the central government to issue a notification under said provision is with regard to the other laws for the time being in force, which the violation of which would come within the rigor of clause small da of section 7d. However, comma, in the notification, yes, in the notification dated August 11, 2025, comma, a general provision was made as to the OCI registration being liable to be cancelled when a person within double inverted has been sentenced to imprisonment for term of not less than 2 years or has been charged hyphen sheeted for an offence entailing punishment of imprisonment for 7 years or more. Double inverted close, full stop. Next para, thus, comma, it is argued that mere stipulation of the period of punishment does not tantamount to specification of the exact laws which come within the purview of section 7 hyphen D within bracket small da. Full stop. Next para, even otherwise, comma, learned senior counsel argues that the show cause notice is vitiated on several other counts, comma, the details of which I have not gone into at this stage. Next para, learned Deputy Solicitor General of India, appearing on behalf of the respondent authorities, submits that the petitioner made several seriously incorrect statements in his application to obtain the tribal pass. Full stop. Next para. By placing reliance on the second paragraph of the show cause notice dated October 28, 2024, it is argued that the authorities clearly mentioned in the same paragraph that the petitioner had obtained a tribal pass based on his previous Indian nationality to visit the Nankori group of islands by hiding his foreign nationality. Full stop. Next para. That apart, he was appointed as Executive Secretary, Nicobar Chamber of Commerce and Industries, bracket NCCI, bracket closed, as per the bylaws of which only Indians are allowed to be members thereof. Full stop. That apart, he had visited INS Kardik within bracket Kamorta Nankori Island, bracket closed, which is a forward operating base of the Indian Navy in his official capacity of NCCI, and Munak village, which is one of the islands in the Nankori group of islands. Full stop. Next para. It is contended, by placing reliance on a photocopy of the application form allegedly filled up by the petitioner for obtaining his tribal pass as to the nature of the false information given therein. Full stop. Under the head within double inverted nationality, the petitioner mentioned Indian, although he had already given up his Indian citizenship on October 17, 2019, and had also obtained the Canadian citizenship on October 11, 2019. Secondly, the petitioner also mentioned his religion erroneously as Hinduism, although he professes Islam by faith. You're a Jew or what?
I come from mixed parentage. I don't profess anything.
Who? Although he is not a Hindu.
I'm not saying
His allegation. I'm putting his allegation. Although he is not a Hindu. Next para. Mr. Learned Mr. Mujumdar, not Mr. Kabir.
Better.
There's Mr. Mujumdar, learned DSGI, further points out that under the head start date and end date of the permission data and location, the petitioner erroneously mentioned March 3, 2020 to May 20, 2020. More importantly, in the last 6 years residence details in the said form, the petitioner had disclosed the start date to be January 1, 2014 and the end date January 30, 2020, during which period he had already relinquished his Indian citizenship and had embraced the Canadian citizenship. Next para. It is sought to be argued on behalf of the respondent authorities by the DSGI that the nature of the suppressions clearly indicate a surreptitious motive on the part of the petitioner, read in the context of his having visited restricted areas and naval and a naval vessel. Full stop. Next para. No, naval base. Naval base. Yes. Full stop. Next para. Learned senior Mr. Kabir, learned senior counsel appealing for the petitioner controverts such allegations and submits that due to certain minor errors, the petitioner could not be hauled up even under section 7D within brackets small a, which in any event,
Not small d.
which in any event, is Mr. Kabir, learned senior counsel appearing for the petitioner submits that the allegation against the petitioner was in the show cause notice was not under section 7 capital D within bracket small a, which is the relevant provision regarding obtaining. No, sorry, Mr. Kabir.
There is some communication
No,
gap here.
no confusion in my mind.
No, no, from that side also, A is not the one, it's DA.
No, Mr. Mujindra never said that. I actually said. Mr. Kabir, senior counsel and senior counsel appealing for the writ petitioner submits that the writ petitioner would not be hauled up under section small d of section 7 capital D of the Citizenship Act 1955 in view of the submissions which have been recorded earlier. Next paragraph. Upon hearing learned, it may also be mentioned here that in the passing comma, Mr. Mujumdar, learned DSGI refers to the petitioner being guilty under provisions of the Official Secrets Act by visiting the naval base. So the next para, however, the court does not find any mention of any violation of any other statute, but Section 7 capital D within bracket small da of the Citizenship Act 1955 in the show cause notice dated October 28, 2024, under in pursuance of which the impugned order cancelling the OCI card of the petitioner was passed. Next para, on a bare perusal of the said provision, it transpires that a sufficient prima facie arguable case has been made out by the writ petitioner, inasmuch as since the notification under clause small da of section 70 was itself published only in the year 2025, the petitioner would not have been guilty of an offence in the year 2020 or even at the juncture when the show cause notice was issued, that is on October 28, 2024, that apart, the challenge to the virus of the notification is required to be dealt with in detail, since apparently the concerned provision empowers the central government by way of notification, only to specify the other laws for the time being in force, for the violation of which the rigors of the said clause are attracted, and not a general provision of the length of offence. Next para. However, the court is of the opinion that if at this juncture, an order of stay of operation of the impugned decision of the respondent authorities to cancel the OCI card is passed, it may have serious implications, since in that event, the petitioner would be entitled to leave the country. Next para. However, since an arguable case has been made out, the court is of the opinion that no coercive action ought to be taken by the respondent authorities on the premise of the impugned order dated April 16, 2026. Next para, since learned senior counsel for the petitioner expresses the apprehension that he cannot even visit Kolkata to see his wife, to attend his wife, who is in an advanced stage of pregnancy, it is also required to be made clear that the petitioner ought not to be restricted from leaving or entering the Andaman and Nicobar Islands or from traveling within the territory of India. Next para, learned DSGI, on instruction, assures the court that the petitioner, on the strength of the impugned order, shall not have any impediment in traveling within the periphery, within the territorial limits of India, including the Andaman and Nicobar Island. Next para, accordingly, the respondent authorities are restrained from taking any coercive action against the writ petitioner on the premise of the impugned order cancelling his OCI card dated April 16, 2026 till August 15, 2026. The date has an implication. August 15, 2026. Load shed. Anyway.
That was divine.
No, not divine.
Lower
Lower than that. Not divine. Administration, Mr. Kumar. Or until further order, whichever is earlier. Next para. That apart, the petitioner shall not be restrained from traveling within the territorial limits of India, particularly between Kolkata and Andaman, between Kolkata, where his family, his wife and family is residing at present, and the Andaman Nicobar Islands, where the petitioner has been born and brought up. Full stop. The FRRO,
Foreigners Regional Registration.
But one thing I need to add, Milord, he should not, Milord, go to the restricted area for the time being.
I'll
Kindly consider.
The foreigners registration and
Regional Registration Officer.
foreigners regional registration officer
Superintendent of Police, Southern.
within bracket FRRO bracket closed, that is the superintendent of police, South Andaman district, shall act on the server copy of this order for the purpose of ensuring that the petitioner may leave and come into the islands.
SP. No, it would not be FRRO, it's Foreigners Registration Officer. The regional.
FRO, foreigners registration officer. Thank you.
That is the SP.
Till August 15, 2026 or until further order, whichever is early. To sub next para. However, the petitioner shall not, for the timing, don't visit Nagpur. Shall not visit. I won't say restricted, Mr. Mujumdar, because there is an argument whether that's restricted.
It's not.
So I'll say Nagpur.
Milord, that is only for tourism, not for any, Milord, the official visit. Milord, your lordship, the act is very
What
clear.
should be the restriction? You couch the language for me. Where should you not go?
Restricted
If I say
area.
restricted, you go to Nagpur tomorrow.
Milord,
He wants that, Mr. Kabir wants me to say that so that he can go tomorrow to Nagpur because it's not restricted.
I won't get a tribal pass.
Oh, tribal pass is there still. No, it was for limited to.
Every time you have to get a new one.
It
Mr.
is-
Rakesh will ensure I never get a tribal pass.
No, please ensure. However, the petitioner shall not, until further orders, till August 15, 2026 or until further order, visit any restricted area in and around the Andaman and Nicobar Islands. The respondents that file their affidavit shall file their affidavit, one set of authorities. If one affidavit in opposition or several set of authorities.
yes, one, for me, one.
So it is different. Respondents shall file their affidavit within bracket S in opposition within 3 weeks.
No, Milord, it will at least 5 weeks. Milord, make it 5
5
weeks.
weeks, no, then the interim order has to be till then.
August, your lordship kept it in August.
August, but 5 weeks takes us. Today we are in. We
April.
don't know if there is a circuit in between. There are 2 circuits in between.
June there is a circuit.
June there is a circuit.
July.
There, 5 weeks is within there. Yes, very good. Within 5 weeks from date, full stop reply if any, replies if any, there within a fortnight thereafter. So liberty to the parties to mention the petition for hearing and support for hearing before the next available circuit after the above timeline for filing of affidavits is over.
One thing your lordship has said, I have applied for the long-term X1 visa.
Yes, it is clarified that nothing in the above order shall preclude the respondent authorities from the appropriate authorities from considering the application filed by the petitioner for long-term visa in accordance with law in the meantime.
Only one more question. The lordship has said no coercive action. Can that also be no coercive action giving effect to? Because I tell you, lordship, otherwise I
Giving effect.
Giving effect means say can't be legal.
No, my lord, it will not work because then in 15 days I have to go and submit it in Chennai.
No,
Then I have no doubt.
that Mr. Mujumdar, I'll make clear. I'll add another line.
Only that part.
Furthermore, না প্রথমে যেখানে বলেছি যে আচ্ছা ঠিক আছে add one line furthermore the petitioner shall remain exempted till August 15 2026 or until further order from no but unless you deliver the OCI card you may use it.
Nothing. I have no paper to show I'm in India. Your lordship desires me to submit it. The minute I submit it, the game is over. I don't have a
If
document.
you have an OCI, then you will hold that OCI card, you will use it.
No, I cannot use it, my lord. If it's cancelled,
Unless you deliver it, how will it will not be
because
shown as.
it's cancelled in the system. I cannot use it at any immigration counter.
Is
Not
that
only
so, sir?
can, Milord, other places he can also use it, Milord.
The minute it is entered into their computer, which it already is, I cannot use it. But if I
But
don't
then what
have
is the
it-
fun of keeping it with you?
No, no, because I don't have a document to demonstrate my presence in India. There has to be a document which allows me to stay in this country. In accordance with law. My passport does not have a visa in it. The visa
No,
is
Mr. Mojumdar, he cannot,
expired.
he, for every nativity, every daily requirement also, he may require that OCI card, but if it's entered in your system, it must have been. So he cannot leave the country.
That your
with that
lordship will make
OCI.
absolutely clear. He is not permitted to leave India.
Milord, can I take 1 minute instruction? Just 1 minute.
Please take it. Acha, Mr. Stephen, where I said that will be restrained from visiting any restricted area, something like that. Did I say that?
My lord is a restricted area in and around Andaman.
In and around. Yes, in and around Andaman.
I'm calling her.
Not so far
Yes,
back. After that. You search with the keyword in and around Andaman. You add there and don't leave the territorial limits of India.
That your lordship has said earlier also.
Oh, then it's just them. Yes, Mr. Mujumdar. What is your instruction? You are muted, Mr. Yes.
1 minute, Milord, just.
Oh, it's still coming.
Well, because I had to communicate her from here to Chennai, then I am getting
No, I
instruction.
understand. Mr. Mujumdar, I have restricted him from leaving the country and from going to restricted places. So I think that is sufficient. Let him
Milord, he
go
has, Milord, I got the instruction, Milord. He has already applied for X1 visa. So he cannot, Milord, keep the OCI card. This is my instruction. He has already applied.
Oh, if you apply for a long time, visa, immediately you have to surrender this.
Yes. He cannot have two things together.
No, he has not yet got it. He has not got
I
it.
get it.
Mr. Mujumdar, unless he
I
gets
get
it,
the visa and
then he will be in a limbo. He will have nothing.
I cannot
Unless
have
he gets,
treatment
if I get a long time visa, if it's sanctioned only, then I have to deposit. Otherwise, how can that cannot be there?
But he has to surrender the OCI card if he has to go through the X1 visa. That is the, Milord, the implication.
No, but if I surrender and apply and you reject, then I don't have anything. Even that OCI card,
But
it will
yeah,
be
Milord,
cancelled without being cancelled.
he said he already applied for X1 visa as his submission.
If he could apply without surrendering that, it must be permissible. No, I'm not very confident of that instruction of your official. Shall remain exempt from delivering the OCI card bearing A3902783 to the concerned authority in the FRRO, Chennai till August 15, 2026 or until further order.
May I just have a copy, my lord, if you have a charge sheet and Xerox and put the Xerox copy.
Charge sheet.
This one, I just shown you also the certified copy.
You have handed over. Yes, please.
I'll make a Xerox copy and
hand it over. Yes.
And may I also have a copy of the documents that they are placing, so I can take instruction on that. That form.
Yes, Mr. Kumar, take instruction whether, because I have to keep it on record. Please, take a copy and give it to me. Give me.
Give them.
Yes, she mentioned first. Yes. 12 will appear under the no, don't record an order. Extension of interim order.
My lord, I have gone by 30. My lord has already passing on the paper directed the authorities to fight.
Mr. Prashant is instigating this.
Same order is passing.
Very top. Yes. No, Mr. Prashant is. No, sorry, you are there. Yes, is completed. Yes. Indeed, everyone is praying for interim order. You know the questions.
Still 10 minutes.
No.
Because due process of law is not followed. Violation of natural.
No obligation. No obligation. Wait for the next. Yes, Mr. Prashant.
11 counts of petition. Claim for speed.
20 and 23.
23 can be disclosed of, take 25.
What was that regarding?
Regarding change of title.
Please just remind me.
Hearing was passed. I filed appeal. In appellate court, party compromised. Land district.
Wait for the next circuit.
Well, justice will be the month of June. It will take only 5 minutes. not
No,
even
no,
5 minutes.
no. All matters can. Not on.
20 and 23 minutes. Only 5 minutes I will take.
Number 28 and 30 are connected matters, my lord. If the matter is not taken up tomorrow, my lord, the nature of the suit property will be changed by the private respondent, though there was stay order by the seated my lord. Despite the fact the Tahsildar and the revenue inspector had went to the spot and changed the nature.
There's already a stay order, you say.
Yes, no.
So
But
then,
we are went against, my lord, content has been filed against.
not so many matters.
Well,
So we won't be able to
My
complete.
matter is required 20 number.
Very good.
Because 7.
Your
counts
quota is fulfilled.
My
Only hard quota is not fulfilled. Yes. 22, 22. 22. 22 topic.
That is all. 20, my lord has said nothing.
I oblige for
I still say nothing.
Well, kindly,
I still say nothing.
item.
No, no.
my lord. Item 20.
No, no, you have mentioned something. No,
No, you lordship has
You-
not
you-
said anything. They rejected or allowed anything.
Rejected.
Direction, my lord, dispose of my representation within a time. Item number 51.
Ultimately, all the matters are being fixed at the top, so nothing will remain.
Direction,
No, no.
dispose of within a time.
Then the other matters won't be fixed. You pick and choose between them.
Yeah.
My one matter, my lord, that is 20.
My lord, my.
No, Mr. Prasant, you have had your feeling.
My lord,
No,
I
my lord.
place,
What is your item?
20.
No, no. Won't tell.
36, 57, 50. Same.
আমি কি বলেছিলাম ডাইরেকশন দিয়েছিলাম একসময়?
না এটা নতুন ফাইল হয়েছে বা আছে এর আগে সে মেনশন
Usually governed by that.
হ্যাঁ তো পুরো
কি করবে?
অর্ডার
এটা কি আমি অর্ডার দিয়েছি?
এটা দিয়েছি same set of communications already in this list also. She has mentioned
This should be governed by the other matter.
this are the same orders to pass in this. That's it.
This will appear together if you have directed. What is the difficulty? GS for a clear.
She mentioned.
No, she's mentioning only two.
এগুলো মেনশন করেছি মানে
These matters are mentioned. This
Yes.
41 to
for similar.
39, 41, 50. Similar matters, my lord has.
they are already appearing.
My lord, these are the similar matters as I have given the order to my lord. One by
As far as
30th
an
of
order
my
filing
lord.
affidavits.
Oh, for affidavits only.
That is the direction lordship of similar matters. Has been-
Same.
Then no matters are fixed at the top. All matters are take up. Whatever matters are fixed. Because there is no meaning here. Top is meaning losing its meaning. Whatever matters are there, whatever matters have not been mentioned will not be appeared. Next. Whatever matters have been mentioned today, those will be appearing.
Well, I'm only seeking for.
Those will appear.
The same order. It may be placed before the next.
Same order. It will appear. Mr. Prasant, your matter will also be there. Then it's in the list.
Yes.
Whatever matters have been mentioned today, just give a list. No, don't. You will add anything else. Something else. Mention them. Take a list. Yours is 22. 22. Yes. Yours. 28, 30.
12 and 51.
12, 51.
12 and 51. There's a
12 and 51. And these other matters,
same order can be passed. Direction.
what are the numbers? 13, 41 to 50. These will appear together as per previous discussion. Mr. Prasant, your matter?
20 and 23.
20 and 23. No, you get lost. Please go out of the room. I don't want to see you, Mr. Kumar. In the courtroom. Outside we can meet. But Mr. Kumar, you forget anything? Yes. Mr. Shivaram. So these matters will only these matters will appear tomorrow. And the extension of interim order and others which I have directed, those will appear.
Not dual.
Exactly.